My name is Lee Edwards. Good morning, everyone. I'm a Professor of Strategic Communications and Public Engagement here in the Department of Media and Communications at the LSE. And we're delighted to welcome you to the briefing today and have you join us to discuss the Online Safety Bill, a hugely significant piece of legislation that will progress through Parliament in the coming year. As you know, the Online Safety Bill encapsulates the government's response to many of the more negative social and political consequences of our digital lives that have been debated extensively over the past decade, and in some cases even longer than that. The importance and scope of the bill is reflected in its size. The bill itself, its explanatory notes, and the associated impact assessment total 342 pages, and I'm sure that you've read every one of them. Published on the 12th of May, the bill has already prompted much discussion in the media, as well as among the businesses and civil society organisations that represent the wide range of actors affected by its content. So the purpose of today's event is to contribute to the process of informing the next stage of the bill's progress, the pre-legislative scrutiny, by bringing together academics, lawyers, MPs, and representatives from Ofcom and DCMS to discuss three key aspects of the bill: regulatory independence and the duty of care, the definition of harm, and the definition and role of the public in the bill, and that of course includes reference to the media literacy component of the bill. The aim then is to have an informed discussion about the potential impact and effectiveness of the bill, from which we can then take important considerations and potential recommendations to pass on in a submission to the pre-legislative committee. We're extremely pleased to be able to welcome a very impressive range of experts as our panelists. I'll introduce them at the beginning of each panel, but for now, suffice to say that they have much to comment on and will provide an excellent starting point for our subsequent discussions about each topic. We're also very pleased to have a wide range of sectors represented in the audience, from legal experts to technology companies and their representatives to civil society organisations and academics. We hope that having such a range of perspectives in the same virtual room will make for a really productive exchange of views. Our panelists are going to be limiting their opening remarks to around 5 minutes or thereabouts, and so we'll have plenty of time in each session for audience questions and discussion, and I'm sure you're all looking forward to a lively debate. As chair, I'll be introducing the panelists for each session, and I'll then curate the questions and answers. Some housekeeping before we start. First of all, we are recording the event and it will be available afterwards via the department website. If you would like your comments removed from any recording, please let us know and then we can edit them accordingly. Please mute unless you are speaking, but do keep your cameras on if possible, and particularly if you're asking a question, so that our panelists can see their audience. Emma has already put this in the chat, but if you just joined, it would be helpful if you could rename your Zoom name to include your organisation if you can. To do this, you click on if you hover over your image and click on the 3 dots at the top right of your image, you'll see the option for renaming there. And when asking a question, please introduce yourself with your name and your organisation. These things help us in the recording of comments and will also help fellow audience members and panelists identify you. Please use the Zoom hand to indicate that you'd like to ask a question. You can see this under the reactions button. You should be able to see the option to raise a hand there. I can't see everyone obviously on a single screen. There are too many of us here. And so using the Zoom hand is the best way to ensure that we don't miss anyone. Please do, of course, use the chat if you wish. And we'll do our best to ensure that any questions that come up via the chat are included in the discussion. If you do want to ask a question, please keep your question relatively brief so that we can maximise the value of the Q&A sessions. And of course, please keep all your exchanges civil and respectful. We're very happy to host guest blogs on the Media at LSE blog site. So if you'd like to put one together based on this event, or indeed more generally about the bill, please do get in touch with us. And if you're tweeting about the event, please tag @MediaLSE and Imogen, perhaps if you could put that @MediaLSE in the address in the chat, that would be great so people can reference it. And finally, if technical glitches arise, as they can over Zoom, please bear with us while we sort them out. I'd like to now introduce our first speaker, Katie Morris. Katie is the head of the Online Harms Regulatory Framework at the Department for Digital, Culture, Media and Sport, DCMS. And she and her team have been living and breathing this bill over the past few months. Katie's going to speak for about 15 minutes to give us a bit of background on the bill and go over some of the key points of the bill to get us started today. So Katie, thank you very much for coming, and over to you.
Thank you, and thanks very much to LSE for inviting DCMS to speak today. It was really excellent to hear kind of how range the participants are, how broad the range of participants are, because I think from the outset we've been really attached to having a multi-stakeholder approach, but it's not often you have all the stakeholders in one room all together. So it'll be a really interesting and fascinating discussion, and we're really glad to be here. In terms of what I'll cover in my presentation, I can see a lot of familiar faces here, and I know a lot of you will be very familiar with the bill, but equally, as you say, it's extremely long, and there's a lot of detail, so we thought it'd be worth kind of going over what it is that government is seeking to do here and kind of talk through some of the key concepts. Before going into that, you mentioned pre-legislative scrutiny, and I think it's worth just giving a quick kind of recap on that and how we expect it to go. So we published the bill in draft in May, as you know, and the intention is to undergo the pre-legislative scrutiny process. For those of you who aren't that familiar with the process, this is a 12-week assessment of the bill by a committee of parliamentarians. They won't look at the bill from a clause-by-clause perspective. Instead, they will look at it kind of in the round and pull out some key thematic issues. And then they'll issue a report at the end of that with recommendations for government. And we'll be looking at that to see where we should be updating the bill if necessary. And we will then go on to introduce it. In terms of timings, because I always get asked this, we are now just waiting for Parliament to set this up. Obviously, there's a lot of kind of energy in this, so we're hoping that will be very soon. And then and then the bill will be introduced this session. I think just on the pre-leg process, it's really critical for us, I think particularly civil servants, to understand, have we got the policy intent right? So during my presentation, I will talk a bit about the policy intent and then how we've given effect to that. And it's also really important that we understand kind of how the kind of policy intent has landed, so that we can continue to take that into account as we iterate. So as I say, really looking forward to hearing the discussions later. So then going kind of straight into the detail of the bill, there's a lot here, so I'm going to jump straight in. So firstly, I think to consider who's in scope. So the bill brings into scope kind of two broad categories of service. Firstly, there is user-to-user services, and secondly, there is search services, which is obviously search engines. A word on what we mean by user-to-user. So this is any service that allows users to post content online, and the bill kind of explains in detail the concept of user-generated content, which is what is bringing companies into scope. In practice, that includes a really broad range of websites and apps, so social media services, video sharing platforms, online forums, video games where they're enabling interaction with other users, online marketplaces, and also kind of messaging services. In terms of where the legislation applies, so it will apply extraterritorially, but we are really clear that we don't want to regulate the entire world here, and so there is a clear need in the bill for the service to be linked to the UK, and that's either by it being targeted at a UK user, or where a service has a significant number of UK users, or if it is clear that a service poses a significant risk of harm to UK users. We've also exempted specific types of service where we consider that subjecting them to the duty of care would either be disproportionate or duplicative. In terms of those areas, so the first is business internal services. So this is things like intranets, where businesses kind of fully control what is happening within that service and will be taking responsibility for it if it's a closed internal system. Email, on the basis that it would be disproportionate, there'd be very little they could do other than scan all users' content, and that would pose significant risks to privacy. Infrastructure providers like ISPs, app stores, given that they don't have direct control over content, so any measures they could take to improve safety would be very crude. Reviews on content that is published directly by a service provider, so that covers kind of below the line comments on news articles and blogs, but also kind of reviews on products and services. And then services provided by educational institutions. So that's not actually in the draft bill, but it's always been our intention, and that is because they're already subject to safeguarding requirements by Ofsted. So then moving to what it is that in-scope services will need to do. So many of you will know the Online Harms White Paper, which we published back in April 2019, which kind of set out the direction of travel and the broad policy intent here. And that talked about a duty of care. And so the legislation still intends to give effect to that duty of care, but to make the legislation specific enough to be enforceable and to give companies legal certainty about what they need to do, we've broken down that kind of overarching duty of care into various types of duties. We've also broken down who those duties apply to, so that not all duties apply to all companies. And the intention there is to build in proportionality from the outset and ensure that we aren't kind of entrenching the largest players by putting disproportionate burdens on smaller companies. So all services will have duties with regard to illegal content and to protecting children. Starting with the duties for illegal content, so kind of the first step is to risk assess for the likelihood of illegal content on services, and then to take proportionate steps to mitigate any risks that are identified. The bill makes provision for priority criminal offences, and these are the offences where companies will need to take proactive steps to identify illegal content and then to take steps to reduce and remove that. They'll also need kind of systems and processes in place that will enable them to respond promptly to reports of any other illegal content that could harm individuals. As I said, also all companies will have duties for children, and the first step there is to assess whether a service is likely to be accessed by children. For those services that are, the government will set out priority categories of harmful and age-inappropriate material that companies need to be first of all, risk assessing for, so is it on their service, and then putting in place those measures to address. Those measures will include preventing access to material that is harmful for children, so things such as pornography, but also ensuring strong protections from activity that may be particularly harmful to children, so such as bullying. Then the bill also introduces this concept of Category 1 providers. So these are kind of high-risk, high-reach platforms, and particularly services such as social media platforms, and they will have the additional duties for legal but harmful content accessed by adults. So what they will need to do, the bill will set out kind of categories of legal but harmful content, which companies must first of all risk assess for, so is that content in scope of their services, appearing on their services, and they will then need to set really clear terms and conditions for how they will treat that content. They'll also need to be risk assessing for emerging types of content, and again to set terms and conditions. I think it's really important to stress here that the bill doesn't require platforms to take specific measures with regard to that legal but harmful content accessed by adults. What it requires them to do is to kind of set those really, well, to risk assess and then set those really clear terms and conditions. So it's much more about kind of closing the accountability gap between what companies say they do and what they are doing in practice. And Ofcom will have oversight of, once they've set those terms and conditions, are they being enforced kind of consistently and in the way that the terms and conditions have said that they will be. Another duty that all companies have, not all companies, the Category 1 providers will also have to publish annual transparency reports, and then all companies will have duties with regard to user reporting and redress. So this will mean that users will be able to kind of report harmful content when they see it, but also they should be able to flag if content has been taken down in a way that doesn't correspond to a company's terms and conditions. And the aim is kind of put that link in so that users have a much clearer route internally to seek redress from services. Search services will have similar but slightly more limited duties. So kind of recognizing the really critical role that search services play in facilitating access to information. The duties on search services don't require them to remove any content, but it's much more focused on kind of minimizing the likelihood of users accessing illegal content on their services and protecting children. And they also have no obligations with regard to legal but harmful content accessed by adults. I talked about risk briefly there, but I think it's worth kind of just going into that in a bit more detail and how it links to proportionality. So as you'll have just heard, kind of a key part of all three of those duties is that the first step is that companies need to undertake a kind of very broad risk assessment for how their services give rise to the different types of harm. And then they are putting in place proportionate measures. And when we talk about proportionality, we're talking about kind of what is proportionate relative to the severity of risks on a service, and the severity of harm that poses to users, but also that service's size and capacity and kind of what is technically feasible in that space. That means that obviously we don't expect all companies to be taking the same measures in fulfilling their duties, and it is much more about kind of embedding that culture of risk management as is proportionate. Companies will be supported in this risk assessment via a sectoral risk assessment, which will be done by Ofcom, who will be overseeing the entire regulation, and I'll go into a bit more detail on their role in a moment. So now I think moving on to harms in scope. So we did touch on this, but I think it's useful to give a bit more detail. And as with the duties, we've obviously got a slightly different approach for determining this for illegal, children, and legal but harmful to adults. So for the illegal, I've already talked through that there's this division between priority offences and non-priority offences. Legislation also, just have a bit of water. The legislation also makes really, kind of puts a really strong emphasis on terrorism and CSEA, and companies will need to act against illegal content where they have reasonable grounds to believe content is illegal. For children and legal but harmful content accessed by adults, content is in scope where companies have reasonable grounds to believe that content risks directly or indirectly having a significant adverse physical or psychological impact on a child or adult of ordinary sensibilities. And in terms of ordinary sensibilities, this refers to kind of sensibilities that are possessed by typical members of the public or kind of otherwise typical people who share a characteristic or membership of a group. So for example, people with disabilities or people of a particular religion. And this seeks to kind of rule out of scope very niche phobias, but does recognise that not everybody will be affected by harms in exactly the same way. And in terms of kind of where the priority categories of legal but harmful content for children and adults will be set out, so following consultation with Ofcom, government will set these out via secondary legislation, and we expect it to include things such as abuse, eating disorder or self-harm content, and kind of harmful disinformation to individuals. The bill also exempts some harms such as kind of intellectual property violations and consumer protections. So now the regulatory structure and kind of the systems and processes approach. So obviously the duties and legislation are quite high level, and that is necessary in order for you to have that kind of duty of care risk-based approach. They will be supplemented by codes of practice, which Ofcom will produce, and they will set out the recommended steps that service providers can take to fulfill their duties. And so these steps will focus on kind of systems and processes that companies can be putting in place. And I think that systems and process point can't really be stressed enough. So Ofcom will then be supervising, have companies put in place adequate systems and processes for complying with their duties, and it won't be looking at kind of individual pieces of content. The recommended steps will obviously be proportionate, and they'll need to reflect kind of different risk profiles and different capacities. Also very important that there will be an equivalence option. So companies can choose to comply by following the steps in codes, but equally they can take alternative approaches, provided that they can satisfy Ofcom that the outcome of those alternative steps is equally good or better to those that Ofcom has put in codes. I'm just checking how I am on timing. I think I've got a bit more time. So I think worth just speaking briefly about freedom of expression. This has been a really key priority for ministers throughout the development of the bill. So both that is in terms of kind of increasing big companies' accountability for their impact on freedom of expression, recognising the kind of significant power that large companies have on public discourse, but also kind of users' experiences of arbitrary content removal. And also ministers are have been very kind of aware that we need to ensure the framework doesn't disproportionately restrict users' freedom of expression. So both Ofcom and in-scope companies have duties relating to freedom of expression, and they can be held to account for those. And here I think just looping back to what we talked about, or what I was talking about of legal but harmful content accessed by adults. So those duties have been designed kind of to increase accountability, and also so that platforms won't be able to arbitrarily remove harmful content. They will need to be setting out, as I've said, in their terms and conditions, this is where they will remove it, and then Ofcom will have oversight of it, is that consistent? And we see that as a significant kind of status move forward on the status quo, where kind of it's not always clear why content's removed in it, and that leads to kind of concerns about arbitrary removal. The other thing is that we've also announced these additional protections for democratic and journalistic content. And so the category 1 providers, so those large high-risk platforms, will need to explicitly set in their terms and conditions how they'll protect journalistic and democratic content when it appears on their services. We've also fully kind of carved out from the duty of care news publishers' content when shared on in-scope services. So Ofcom's oversight of the system, I've said quite a lot about its role in terms of the codes of practice. It will also obviously have a series of enforcement powers which it can use against any company that fails to fulfill its duties. So this includes a kind of range of different measures, including fines for companies of up to 18 million or 10% of their qualifying annual global turnover, whichever of those is higher, and also kind of business disruption measures. And that could include applying to a court to block access to services that cause kind of serious harm. The government expects that Ofcom will prioritise enforcement action where children's safety has been compromised. And the bill also sets out that Ofcom will be able to pursue criminal action where a named senior person kind of fails to ensure that their company complies with its information requirements, or where there is no named person in there, a senior person who is complicit in that. Those criminal sanctions will be deferred and they won't be brought in unless there's a need to kind of push compliance in the sector because industry are not fully engaging with those duties. So then just very briefly, Ofcom will also have a series of wider duties to help oversee the regulatory framework. So these include really broad information gathering powers so that they can get the kind of data and information they need to inform all the other aspects of the framework that they will be delivering. They will also be able to accept super complaints. So Ofcom will need to set up a super complaints function and also user advocacy mechanisms, which will make sure that it is kind of really understanding users' experiences, detecting issues early and kind of addressing their concerns. And one thing I should have said on the codes of practice is that Ofcom will also have a duty to kind of consult very broadly when developing those to again ensure that you've got that kind of loop, that feedback and users' experiences and industry experiences are kind of informing the development of the codes of practice. Ofcom also has the ability to require a platform to use technology to scan public and private channels for child sexual exploitation and abuse material. That is a measure of last resort and will be subject to really strict safeguards to protect users' rights. Media literacy, so it has duties to act to improve the media literacy of UK users and to encourage industry to act in this space. And it will also be setting up an advisory committee on disinformation and misinformation. So that is a really whistle-stop tour. I'm really looking forward to hearing the discussions and happy to come in on any points of clarification. I know that there are a lot of DCMS colleagues on the call and also I believe some from Home Office. So I think between us we should be able to answer any questions that you have.
Thank you very much, Katie. That was really helpful. We have about 5 minutes for people to ask questions of clarification. I know that many of the things that you've described will come up in the later discussions as well, where we'll have more time to reflect on them. But for now, does anybody have any questions of clarification that they would like to raise with Katie before we go to the first panel?
I had asked a question in the chat. Can I repeat it here?
Yes, please do. Yeah.
Hi, Madeline Earp, Committee to Protect Journalists. I picked up on your mention that email providers would be out of scope because there would be little they could do to comply except scan everybody's private messages. So my clarification question is whether private messages exchanged on social media or WhatsApp would be in scope, and what's the difference in that case?
Yeah, it's a really good question. And yes, they will be in scope. We've looked at this really closely. It was one of the hardest questions, I would say, to resolve. And our assessment is that there's an awful lot that kind of tech companies such as WhatsApp can do that doesn't require looking at the content. And so we would expect Ofcom to be setting out in its codes kind of the range of measures that they can take to do with private messages that don't require actually seeing what that content is. So sorry, that's quite abstract. To give some examples of that, things like we know that WhatsApp put in place their kind of measures to stop people repeat forwarding things on. We also know that a lot of the companies use group names to identify things. There's also lots they can do in terms of enabling users to block and report harmful content. And obviously on email, it's kind of quite difficult conceptually to see how you would do that, but there's quite a clear sense that you can get that spamming on a messaging service, particularly when it's tied into that broader functionality on something like Facebook. So users should be able to kind of block that, report it, and kind of take those safety measures that are much less invasive on users' privacy.
Thank you, and thanks for that question, Madeline. We have a couple of questions in the chat, one from Velislava and one from Ralitza. So Velislava, would you like to ask yours, and then Ralitza? Okay, there's a pause there. So I'm going to ask the question instead. So do you address a possible privatization of knowledge with respect to education technology platforms, drawing on your effort to safeguard democratic journalism? Are you going to address any of that kind of educational side of things, or is that kind of out of scope?
I'm not sure I've understood the question. Apologies if I'm being incredibly slow. I'm just looking at the question.
Maybe when Velislava comes back, she can clarify that herself. I'm in the same position as you in relation to that one. Ralitza from Shout Out UK.
Yes, hi, hello. Thank you very much for explaining and running us through the bill. I've got a question around the on media literacy side of things, in particular the advisory committee on misinformation and disinformation. Would you be able to elaborate a little bit more about the functions, the decision-making powers, and just in general, how can civil society organizations be involved? Thank you. Sure.
So I have to say disinformation is not my area of expertise, but I will do my best here and happy to follow up on it. So I think we've kind of set it up fairly broadly, but the idea is that it should have a broad membership that could include rights groups, academics, and companies. And kind of the key aim is really to bring together that multi-stakeholder group to understand how disinformation is appearing online and to build up that technical knowledge, and then make recommendations as to how you can tackle disinformation. I think that is really important when you bear in mind the additional information gathering powers that Ofcom will have in this space, because it takes us much further forward in understanding how it appears and therefore bringing together that expertise as to how we could address it.
Thanks, Katie. I'm just going to take one more question from Graham Smith, and then we'll move on to the panel.
Sorry, just getting my video in order. Yes, Katie, hi. You mentioned for persons, adults and children of ordinary sensibilities, you mentioned particular religions. Does this mean that blasphemy is to be regarded as harmful?
My instant response to that is no, and our policy intent is absolutely that that would be problematic, but I think it might make sense that we kind of go into the more detail on that going forward. But the way it's defined, I think we're clear that it's got to hit that threshold of severe psychological and physical harm, and I don't think we would think it does.
Well, to follow up on that, there are many people who claim that blasphemy has very traumatic effects on them. And of course, for this, you don't have to prove any psychological harm. It's purely, a reasonable grounds to consider that there may be a risk of psychological harm. So, those people who claim that blasphemy is traumatic, I mean, you say it wouldn't be, your reaction is that it wouldn't be in, but why wouldn't it be in? And why are we only starting to think about this now rather than back at the white paper stage?
So I think my main response on there would be, I think blasphemy to me seems like a very high level term here, and you'd have to look at how it's manifesting in different ways. I think there is, it's really important to remember what the duty on companies actually is. So blasphemy, I think we'd all accept, is unlikely to be illegal unless it was being used in some form to kind of harass people in a way that met a criminal threshold. Where it falls below that threshold, I think there is still that work to kind of define what the priority harms are and what needs to be in codes of practice. What needs to be in the priority harms and what companies are risk assessing for. I think then once you've done that, it's about companies setting clear policies. And I think you would need to really break down what you mean within that. And are you talking about harassment? And are you talking about different formats? And how does that go? And then that would kind of map across the different categories of harm that we've set out.
I won't keep pressing you, but I have lots to say to that.
There is more time to discuss later, and I'm sure these things will come up. Katie is going to be here all morning. And Sonia, thank you for offering to clarify Velislava's question. Can I suggest that we actually leave that perhaps until later discussions as well, because I don't want to drift on time so early in the day. So let's keep hold of those questions. If you did have questions, please do come back with them later on. Katie will be here all morning. She's also part of the final panel. And so I'm sure she'll be interested in everything that is said this morning and then can respond further at that point as well. So let's move then to the first panel discussion, which is on regulatory independence and the duty of care in the online safety bill. And I'd like to introduce our three panelists who will present in the order in the programme. So first, we will have Professor Lorna Woods, who is Professor of Internet Law at the University of Essex. She's currently researching the impact of positive obligations under freedom of expression on media and telecommunications regulation. She's recently published an article on executive accountability and national security, and of course was an architect of the idea of the duty of care as well. So Lorna, welcome. Dr. Damian Tambini is our second panellist. He's a distinguished policy fellow in the Department of Media and Communications at the LSE, where he also serves as Programme Director for the MSc in Media and Communications Governance. In his latest book, Media Freedom, Tambini surveys the history of media in the US, the UK and Europe in order to develop a new theory of media freedom that's capable of resolving current controversies, and he's been very interested in the development of this bill as it's gone forward. And finally, we have Onwurah MP. Onwurah is the Labour MP for Newcastle upon Tyne Central. She currently undertakes the roles of Shadow Minister for Business, Energy and Industrial Strategy and Shadow Minister for Digital, Culture, Media and Sport, and has long been interested in this area. So thanks to our panellists for joining us, and I'll hand over first then to Professor Woods.
Thank you for inviting me. A few remarks in this area. I think following on from Katie's outline of the draft bill, we've all got the message that the role of Ofcom is going to be significant in, I suppose, detailing the nature of the duty of care. Now, within reason, I think this is a sensible move. I say within reason because ultimately some choices should be made by Parliament rather than either independent bodies or the executive. So there is a question of balance of decisions to be made. But I think the use of an independent regulator can have some benefits in terms of being able to, I suppose on a pragmatic level, free up parliamentary time from points of detail, but I think more importantly, allow technical decisions to be made on the back of research and using technical knowledge. So in principle, say, looking to codes, to me makes sense, and it's actually not novel. We've already got a system, not just in the context of broadcasting and communications, but in a lot of areas where an independent regulator sets down more detail. You can see it in data protection. You can also see it under the Health and Safety at Work Act, where further details given by the regulator. But it does mean that the independence of the regulator is important. Now, across a wide range of areas. We've seen this coming from the European Union in relation to, say, telecoms regulation, in relation to data protection regulation, and most recently in relation to broadcasting regulation. And while the concerns in some areas might be about safeguarding competition, I think in the broadcasting and communication sphere, there is a significant public interest in play, and that is ensuring diversity, ensuring a range of views are heard, and I think crucially, not allowing the political element, but specifically the executive, the government, to manipulate the media for their own ends. And you can see that in the Council of Europe recommendation from 2000, recommendation 2023 on the independence of regulatory authorities in the media. And it's against that background that I suppose I'd like to flag up that while the mechanism of deferring or delegating responsibilities to an independent regulator is not new, there are some provisions, I think, in the draft bill that we don't find in other existing legislation. And if anyone can prove me wrong on this, I will be grateful to hear them, because I've not reread every single provision of every single act. But I'm putting my glasses on so I can see this. So in terms of the codes of practice, we've got a consultation process, as Katie has mentioned, but then the code of practice is to be approved by the Secretary of State and then laid before Parliament. Now, on one level, the laying before Parliament has been seen before. If we look at the Age Appropriate Design Code in the Data Protection Act 2018, we see that there. But what I note in these provisions is that the draft bill specifically allows the Secretary of State to direct Ofcom to modify the codes of practice. The Secretary of State can give Ofcom guidance about fees. I'm probably not so worried about that. And the other one that I have noted in my little list for my raised eyebrow face is the statement of strategic priorities. I think that's clauses 57 and 109 at the moment. Another one which probably doesn't give me too much cause for concern is the direction about advisory committees. So I suppose I have questions about when and how these directions will be deployed, if at all, and the impact that that might have on Ofcom's freedom to assess the evidence, to make its own choices about risk, about appropriate responses, and about where the risks lie. So that's my question. I suppose the point is, I've not seen examples like this before, and I think that in the context of freedom of expression, of diversity, and of the media, that it's particularly sensitive. I want to end by saying that although I've flagged these clauses, I don't want to overstate, because I'm also aware that there are some compensatory mechanisms in the draft bill. So in the interests of balance, the codes of practice do get laid before Parliament, so it's not just the executive that is involved there, though it is the negative resolution process, not the positive resolution process. Clause 33(2) does limit that some of the nature of the Secretary of State's powers of direction, but I'm not quite sure how that will work. And obviously, if Katie wants to come back on any of these questions, I'd love to hear the answers. And more strongly, the statement on strategic priorities is subject to the positive resolution process. So although Ofcom can be instructed on the back of that statement to reflect those strategic priorities, the strategic priorities are subject to parliamentary oversight. I'll hand over at that point to Damian, I think.
Thank you, Lorna. Thank you, Chair. Thank you for the invitation. I'll start off by just acknowledging that there's emerging quite a broad, vociferous body of opinion, some of which we'll hear from today, which argues that the entire concept of a duty of care is flawed and mistaken. I think that this, as the policy debate goes on, this body of opinion, I think, will say that we should be starting again with the bill. I'd actually start by saying that I don't belong to that group. I think that what we need is a debate about what constitutes harm. I think we need societal processes of deliberation to think about what is the appropriate balance of freedom of speech and harm, and who in this new multi-stakeholder model should be responsible for regulating what. And I think what the duty of care does and should do is create that framework and make it happen, because the normal processes of market competition are really not delivering protection from harm, and neither is self-regulation. So the rejection of the duty of care is based on arguments around freedom of speech. So, for example, Index on Censorship argue that the bill fundamentally shifts who controls free speech in the UK from Parliament to Silicon Valley. And that Silicon Valley companies in the new regime will be responsible for moderating, censoring, including content which is legal but harmful. And I think the argument basically overstates the case. I think the duty of care process does not completely shift the framework for regulation. What it does, because at the moment Silicon Valley is setting the terms and conditions, they have market positions which enable them to privately censor and enable them to balance rights in whatever is in their economic interest, which is not currently to protect people from harm. And we need a more caring platform ecology. So that's my starting point. But I do think that there are problems with the bill as it's currently drafted, and there are also ways in which I think, in particular, picking up the points that Lorna makes, the role of Ofcom and the independence of Ofcom really needs to be looked at again. But just to mention on the duty of care, whether it's mistaken or not, of course, the duty of care is not just about removing illegal and harmful content. It's also about duties to uphold the freedom of expression of users, which are quite clearly set out in the bill. And these will be included in the impact assessments, as will the Section 12 and Section 23 protections for journalistic and democratic content. So, yes, platforms can be admonished if they don't meet their own standards for reducing the impact of harmful content, but they can also be admonished for failing to meet their duties to uphold freedom of expression. So I do think platforms should be more responsible and that a duty of care can be made to work. And I'm just going to list a couple of things which I think need to be addressed. And the linking concept here is legitimacy. How is it possible to create a framework for speech accountability that's not subject to capture by narrow social, political, or economic interests, and it is widely understood as such? This is the problem of trust. How do you have a framework of rules which enjoy the trust of the public and is not seen as capture by the executive or the government or some other construct? So I think that the rules should be held up against the standards of transparency, procedural fairness, and above all, independence of regulatory authorities. And I think the Council of Europe standards, which Lorna referenced, are the right ones. And I think it's an interesting comparison here. If we look at the Digital Services Act, which is the European Union's framework, and if we were still in the European Union, we would be implementing the Digital Services Act through the online safety bill. But Article 39.2 of the Digital Services Act sets out a very high standard for regulatory independence. All digital services coordinators have to be completely independent of government. And I think it would be a useful standard to read the bill alongside. It does not currently meet that standard. And I think we need to acknowledge really that successive governments have not effectively protected Ofcom independence. And we can see in public debate around appointments that this is likely to be continued. So we should acknowledge that the digital the online safety bill requires a more independent Ofcom, not a less independent Ofcom. And that there are multiple ways in which the process, for example, of developing codes of conduct compromises the independence of Ofcom. So, for example, and we can come back to this, we could list the sections. So the Secretary of State powers to approve codes of practice have already been mentioned. To give directions to Ofcom, sections 32, 33, and 111. I'd say that these need to be narrowed and much more specific, and that independence protections need to be guaranteed on the face of the bill. So there's too much of a role for the Secretary of State. For example, Part 6 of the bill gives powers to the Secretary of State that need to be, in my view, exercised by Parliament. But I would argue that in relation to some of these powers, and this is a point that I'll come back to, there might be a role, and we might see a more progressive and, if you like, cutting edge piece of legislation if some of those powers may involve in a more, in my view, legitimacy enhancing way, may involve citizen involvement. So citizen juries, citizen assemblies, and deliberation. And I'm going to come back to this point. So section 113 and 113(1)(a) is an example of a power which doesn't really, I think, belong in a Western democratic framework. And these kinds of, even if it has additional safeguards such as those that Lorna mentioned, these kinds of functions really should be separated much more clearly from the executive. Second point is the muddying of the boundary between illegal and harmful content. Now, this is something which we've discussed at length. And in principle, I would argue that illegal and harmful content clearly require different procedures. So illegal content is a very narrow category, which is defined ultimately by Parliament, and there are very clear procedures for law enforcement in dealing with it. But harmful content, there's more of a role for consumer choice, deliberation, and there's more subjectivity involved, and there should be the freedom of users to migrate between different services. But on the other hand, the requirements of efficiency of moderation and efficiency of platform management will ultimately mean that these categories at the platform level, in terms of how they are translated into moderation, into terms of service and so forth, do coincide. So I would argue that the bill should be amended to make clear that whilst the codes may mention and set out standards for both, procedures are separate. And what we want to do with the bill is incentivize a debate about where harm is occurring and what the ethical responsibilities are of all actors. Point 3, I think that there is a really a lack of a, if you like, a clear limitation and a coherent approach to ministerial involvement. So ministers are involved in codes of conduct and definition of harm. That's including content which is harmful to adults but legal. And I can't see what the justification for ministerial involvement is in that stage. And again, here, I would say that there is a potential role for a more bottom-up approach involving citizen assemblies, citizen juries, and representative panels and boards, rather than a minister, given that there is clearly a conflict of interest in direct executive control of speech. So I think we could list also the areas for discretion over content standards. Definitions of journalistic content is another one, section 14. The platform is involved in defining those kinds of standards. And I would like to see, and again, we could go through the bill in a more systematic way to say, well, in these definitions of content standards, where is the platform really the best body to be making calls, for example, about whether journalistic content is, whether something is journalistic content, and what is the role for a minister and effectively negotiating between ministers, Ofcom, and the executive, those kinds of codes, and why don't we have more bottom-up involvement in that?
Damian, if I could ask you just to wrap up shortly, I'm just conscious of the time,
yes,
and I do want you to have plenty of time to speak.
I'm coming to the point. I won't make the point about a lack of discussion of social harms and disinformation, which a later panel is making. But I just want to wrap up by saying that I think that if there's one key message about the bill, it might be that we are, there will be opposition to the bill. It will be based on freedom of speech. It will focus on things like too much ministerial involvement and a lack of independence of Ofcom. And I think a creative way of responding to that opposition to the bill will be more bottom-up citizen involvement in those kinds of decisions, particularly around content standards and discretion. I'll just close by pointing out that the session is chaired by somebody who has a great expertise in running citizen juries and citizen assemblies. She wouldn't promote herself, but I hope she doesn't mind me doing so. And I think that that's really where there would be an interesting creative response to what will be inevitable opposition to this bill.
Thanks very much, Damian. Fascinating and many ideas to discuss in the Q&A. Let me hand over to our third panellist, Onwurah MP.
Thank you very much, Lee, and I'm really delighted to be asked to speak today, and very pleased to follow the two experts such as Lorna and Damian. And I particularly agree with the point that Damian made on recognising the actual facts on the ground with regard to platform power dynamics as part of this discussion. But their expertise allows me, in my time, so I keep time, to take a more political, if you like, perspective. But I'm going to start from an engineering perspective, because I'm a chartered engineer and I spent 20 years, actually 17 years, building out the networks that have since become the internet, and then another 6 years regulating them as head of technology for Ofcom. And I'm very proud of that work, and I am proud of what those networks have become. Accelerated by the pandemic, we are increasingly living our lives online. And for those who are not, apart from the 10% who are digitally excluded, at least 10%, social media platforms such as Facebook, Google, YouTube, Instagram, and Twitter, they're all now woven into the fabric of our lives. And together with the vast array of online apps for everything from video conferencing to healthy eating, they're a critical enabler of an active life for citizens, consumers, and any economic contributor. But nonetheless, even as a technology evangelist, which is my starting point, I have to acknowledge that the internet can be a dark, challenging, and inhospitable place for my constituents. Content is created by tech platforms that allow the spread of disinformation, sexual exploitation, fake news, extremism, hatred, and other harmful content. Since the outbreak of the pandemic, the Internet Watch Foundation have reported rocketing online child abuse. And on TikTok, the hashtag vaccines are dangerous has had millions of views to date with almost no misinformation warnings. Put that as a context to say that I find it is incredible to me that it wasn't until November last year that online harms, there's a debate on online harms in Parliament for the first time, and it's taken the government even longer to bring forward, well, it's what we have now is the draft online safety bill, which is yet to enter pre-legislative scrutiny, which will say if it takes about six months, we are still some time away from an actual bill for consideration. And this has been already at least 3 years directly in the making in terms of discussions around having an online harms on life safety bill. And I would say 10 years, since I came into Parliament in 2010, this is when we should have been discussing the challenges and as well as the opportunities which the internet raises. So I'm going to go look at a few points. I could talk about this for a long time, but I'm going to try briefly a few points. Firstly, I know there's a panel discussion which is focusing on this more next. So, but firstly, the biggest failing for me of the bill is it fails to go far enough to ensure people power, not platform power. But this is an opportunity to look beyond just how to prevent specific individual harms, but to explore how as a society we can reassert democratic power over large platforms' power. Increasingly, it is clear that one of the defining questions of our time is to what extent do digital technologies control our lives and democracy, and on what terms? And the draft bill focuses on the second part, on what terms, but underplays the central first part, who has power. The benefits of the platform provides are very individual, but the harms, as well as being individual, are also collective. And we need to collectivize our response. And we fear that the government are ignoring the very real concerns of the public over the balance of power in the online world. And a poll by YouGov found out that 90% of the public supported tougher legal requirements on tech firms. And I fear that the government have been too enthralled to the power of the platforms to provide a watered down weak piece of legislation that doesn't go far enough. Then on prevention and enforcement against harm specifically, we have to ask, firstly, if the platforms are doing everything they can do to minimize the presence and prevalence of online harms, my answer to that is speaking as an engineer here, is no. The incentives are not there. The incentives are to maximize eyeball time. They are not to minimize harm. And the firms have the ability to swiftly take down harmful content, but it's often left unaddressed for days before action is taken, at which point the harm has already been done. But the duty of care that the bill sets out is a significant step forward, but questions still remain over the effectiveness that data sharing, for example, data sharing with law enforcement has in its current form, and also with the absence of any. This is not a rights-based approach. So we are in a digital age, but this gives no digital rights to citizens. Our position is that we need a charter of digital rights, and part of that is putting people in control of their own data, which this bill does not do in any form. So we want to see a clear strengthening of that relationship and a greater clarity on, for example, age verification, anonymity, and end-to-end encryption. And obviously, we've spoken about already, the government must be careful to strike the right balance between accountability and anonymity. Anonymity can be a shield for brave whistleblowers, for victims, for children and minorities looking for self-expression. So we're not saying to simply ban online anonymity, but I am pleased that the bill provides some carve-out for journalists, but it still desperately needs clearer definition of terms such as journalism and harm, the absence of which makes the harm-freedom trade-off hard to calculate. And another vital aspect of freedom is the need for algorithmic fairness. The bill fails to appropriately factor in the role that algorithms may play in targeting specific groups for censorship, and Labour will be working hard to ensure that that is corrected. Finally, we have to ensure that the bill provides a boost to competition and innovation. It cannot all be the large platforms to benefit from uneven costs of compliance on smaller firms. We need a level playing field where the CMA and Digital Markets Unit work systematically with Ofcom and the ICO to assess the overall impact of regulations on competition. Remember that the Digital Markets Unit will not have enforcement powers for at least 2 years, given that it hasn't got any legislation coming in this session. So this bill could present an opportunity for innovation, but it doesn't go far enough. In discussions I've held with tech firms and trades bodies, it's clear that the absence of clear regulatory framework within which to work has been harmful to innovation. So we must look at a way this bill could provide a proactive boost for responsible tech startups, turbocharging competition, and giving customers a real choice between services built on proper platforms, APIs. Much more I could say about the absence of financial scams, the absence of data rights, the absence of algorithmic harms, addressing algorithmic harms, digital surveillance, etc. But just to conclude, we welcome the bill, as some legislation in this area is better than none, but our concerns are clear. We look forward to discussing the bill with you today, and I'm really looking forward to learning what people's positions are and exploring how we can best work with the government to deliver the effective, robust and substantial regulation that UK citizens and businesses have long needed to keep us safe online. Thank you.
Thank you very much, Jean. Thanks to all the panellists for those presentations, which start us off on an interesting discussion, I'm sure. I'll open the floor to questions then. As I say, just a reminder, if you have a question, the best way to ask it is to raise your hand via the Zoom, which you can find in reactions. That makes sure that I can see you. But if you do need to use the chat, for example, if your sound is off, then please do use the chat and we will try and keep track of the questions that pop up in the chat. So I do have a question in the chat at the moment that's popped up from Iglika Ivanova. Iglika, would you like to ask your chat verbally? Do you have sound?
Good morning. Thank you for giving me the opportunity to ask my questions. Here they are. The first one is about the transposition of the Audiovisual Media Service Directive into the UK law, and more specifically the Article 28B regarding the video sharing platforms like YouTube, and how is the AVMSD influencing and or complementing the online safety bill. Another one is in what way the development of the proposal for a Digital Service Act is influencing the policy debate and the legislative process in the United Kingdom. How far or how close those two frameworks and pieces of legislation could end from each other, and why? And how are the safe regulatory codes of practice and conduct on hate speech and disinformation? And we are comparing these two codes because the one is to illegal content and the other one is to legal but harmful content. How they are seen as a possible approach, as working solutions. I know that these are too many questions, but they are in some way related to each other. I will be thankful to have some opinions on them. Thank you very much.
Thanks, Iglika. I think that, I mean, Katie and the DCMS team might want to respond to the AVDSM question, and then perhaps the panelists can bring up the, can respond to the other areas of the influence of the DSA and how it might influence this process here in the UK, or how close those pieces of legislation are along with the codes of practice.
Sure, I'm happy to come in, and actually on both. I think on the DSA point, we obviously work really closely with international partners. For this regime to work, we're going to need to have cooperation everywhere. So I think keen to learn from each other and do cooperate closely with EU partners. On the AVMSD point, so the underlying principles of both regimes are the same, so both have that kind of focus on systems, regulation and protections for users. And I think the key difference we see is this kind of introduction of more kind of granular duties and the duty of care, and then this extraterritoriality which is introduced. So under the video sharing regime, Ofcom's only regulating services within the UK's jurisdiction, and so under online harms, it will regulate any in-scope services provided to UK users. I'm not an expert on this area though, so I'm happy to kind of follow up with the team, but we're obviously kind of taking account of it as we develop what we're doing here. Everyone's also frozen for me, so I don't know if you can still hear me.
No, we can still hear you, yeah.
Okay.
Thanks, Katie. Can I open that question to the panelists, if any of the panelists would like to respond as well?
Can I just give some more point detail on the Audiovisual Media Services Directive? The transposition was implemented in the UK by a statutory instrument amending the Communications Act, and it came into force last year from the 1st of November. As Katie said, Ofcom's the relevant regulator there, so there is a sort of clear opportunity for, I suppose, Ofcom to do some learning, at least with that subset of actors who are video sharing platforms that will then fall within the online safety regime. Ofcom is in the process of developing its guidance, and it has been consulting earlier this year on which bodies are in scope, and it has also been consulting, and I think the consultation is still open, on some of the substantive obligations in Article 28B. So if you have a look at its website, you can see what it's doing there. As Katie said, the provisions don't have extraterritorial effect, so there is a limited number of platforms that are within this regime. And those who like points of detail should note that when the online safety bill comes into force, it will actually repeal the relevant provisions that are currently in the Communications Act on video sharing platforms. So that's some more sad techie detail. I think the interesting question for, I suppose, the relationship between the Digital Services Act and what's being done on online and safety, and also with regards to video sharing platform provisions, is there is a basic similarity, I suppose, in that there is a focus on techniques relating to the features and the functions of the platforms. And you can see that in the list of possible appropriate measures in Article 28B. I suppose the interesting question for me is, if you say that that is a base level of similarity, how far do you go with difference and different emphases before you actually turn in to something that is different? If you want to pick another similarity, this is category 1 and very large online platforms. There is a recognition of, if you like, at least size, though category 1 also takes into account riskiness. Recognizing that, I suppose, in both systems, the ability of certain dominant platforms to shape public discourse. I'm going to dip out of your comments on disinformation. I know there's a panel on that later, so that's my justification for dodging more difficult questions.
Thanks, Lorna. Damian or Chi, would you like to comment?
I'll just agree. I was actually the shadow minister on that SI that introduced the provisions of the AVSM, and it's, you know, thanks to the comments that Lorna made, but also to say that that it's clearly, if you like, a sort of it's an interim. The minister made it very clear. It's a sort of interim measure whilst the online safety bill comes into place, and the online safety bill is not going to be in place for, let's say, at least another year. Whilst obviously that gives opportunities to learn, as I think we've said, it also it also makes it a sort of transitory, which doesn't give the kind of certainty that we need. But I think that, you know, overall this dynamic between retaining compatibility with European Union legislation and taking advantage, as the minister put it, of the opportunity to diverge, and the implications for European businesses, UK businesses, and for like data adequacy, etc., you know, is another area of uncertainty. And the other point I would also make is that in terms of European Union, the draft the UK was ahead, you know, for many years when it came to the regulation in the communications sector, starting with the 2003 Communications Act. But we have fallen behind, and the European Union's Artificial Intelligence Directive is much more forward-looking, and in addressing and giving rights and principles around the regulation of artificial intelligence and future harms.
Thank you, Chi.
Thanks. Yeah, I think that my co-panelists have dealt with that question pretty well. I mean, I was going to suggest I take the next three in the chat, which from Matthew, Andrew and Richard, which are very much a group. Is that okay?
Yeah, absolutely.
I mean, these questions which relate to, you know, I think the central dilemma in all of this, and the reason that, Katie, I have been sympathising with you during this whole process, it's a very difficult regulatory design problem we have, because as the questions indicate, I'm assuming everybody can see them, there is a problem of vesting regulatory power over speech with an independent regulator and with a minister for different reasons, when traditionally you might think that independent courts deal with those kinds of questions rather than either private actors or the executive. And of course, in principle, that's true, but regulating speech on this scale means that realistically, you can't have court cases making decisions about whether speech is legitimate or not. What the framework does is delegate down to platforms some of that. But I think, and this is the missing point, what it also does is create a structure for making that transparent, codes of conduct, making that process of reaching those codes a bit more thought is given to the role of Ofcom in that and the consultation which goes along with that. So I think I agree with the values behind those questions, but I think we're on very new territory here when it comes to regulating speech and duty of care. So we need new kinds of concepts. I think the duty of care is a useful way of thinking about those problems. I think, as I mentioned, just to pick up one of the points that she made, one way of resolving that is to actually shift some of the burden, not to either private actors or to ministers, but the term she used was people power could have more of a role to play in these regulators, or to use another term, maybe we should be talking about big society regulation. Civil society type bodies being involved, more citizen jury, citizen representation rather than those bodies.
Thanks, Damian. Let me invite Sonia to ask her question.
Brilliant, thank you very much. Yes, I wanted to pick up on Onwurah's mention of human rights and thinking about the balance of rights. And just to kind of reflect what are very kind of clear concerns in the chat and in the commentary around the bill on whether a duty of care can be enacted in a way that respects freedom of expression. So I guess my question is to invite the panelists to comment on how the bill strikes a balance between regulation of content and regulation of systems. And systems, clearly there's a lot on search, algorithms. I'm also thinking about what we call platform power more broadly. So what exactly, how is that balance struck? And it's sometimes, I know, being called the difference between managing freedom of speech versus freedom of reach. Is that a meaningful distinction? And where does the bill fall down or stand up?
Thanks, Sonia. Who would like to start with the response to that question?
Can I go first?
Sure.
Because I think I'd like to say something about the nature of freedom of speech to start off with, because there's a tendency to look at it just as individual person speaking, and sort of the analysis takes that two-party almost out of context model. And I don't think that reflects the case law of the convention or the reality of the situation, where we are back in the land of mediated speech once again. Sort of back in the 90s, there were some people who got very excited and said, "Oh, this is the end of sort of the gatekeeper, and we are in the time of disintermediation," and that isn't the case. So we perhaps need to go back and engage in a project that was, I think, first flagged up in the early 60s, that we need to think about how we have perhaps a freedom to communicative environments where we've got private actors mediating speech, and that we also have to hold the balance between multiple different speakers and how potential conflicts between those speakers are actually taken into account. So I'd just like to say that I don't find a lot of the debate, while I accept that the rights aspect in this is very important, I don't think the way it's characterised at the moment is necessarily the most helpful. And we need to remember that, as well as a speaker or multiple speakers, there's the impact of speech. So there's the potential silencing effect of some speakers on others. And we can say that this is, you know, an example of this is the abuse of journalists, the abuse of people in public life, especially if they are women or in a minority group, and those sorts of considerations. But we need also to think about whether the platforms themselves have any rights, how rights against private actors should be understood, and then what other sorts of rights should be coming into the equation. Because it's a basic principle of international human rights law that human rights are equal and indivisible. Freedom of expression, even online, is not more important than other rights. And we could talk here about the right to safety found in, say, Articles 2 and 3 of the European Convention. That's the right to life and the right to be free from inhuman and degrading treatment. So that is my starting point. I did notice, and I don't know whether this was DCMS taking corporate social responsibility seriously, but I find the fact that the obligation to take into account freedom of expression and privacy is set out separately from the other issues, so that it is actually seeing the specific nature of fundamental human rights, and it's not lobbing it in with a generalized risk assessment approach. And that is, I think, quite important in valuing the rights that need to be taken into account. I am slightly concerned that it's just talking about freedom of expression and privacy and not other rights, though they are the two most obvious. So I'll stop there and let other people get a word in.
Thanks, Lorna.
I want to just say firstly that I am, this is 2021. These issues, when I first entered Parliament 11 years ago, the response to women, particularly being attacked online, was don't respond, don't feed the trolls. Left the web sort of as a safe space for the trolls. What really upsets me is that we are sort of 10, 12 years into this is an issue, and we are still not having a public debate about it. And that this bill basically puts the decision, it gives the powers to the Secretary of State, so it isn't a debate for Parliament or to people power. We need, because there are important and critical trade-offs to be made here, and it isn't like there is a right answer, one right answer. It has to be a societal consensus, which was built up over many years in other different areas. We talked earlier about blasphemy, that's changed. But we haven't had that debate, and now we have a bill which kind of enshrines some parts of an answer in stone. And another thing that upsets me is the idea that I have to choose between Trump and Facebook in terms of who is deciding what should be online. No, that should be a public debate, part of a parliamentary debate as well, and then we have a social consensus. And so I think that's a huge act of negligence by the government, the Conservative government, who has been in power for the establishment, if you like, of the internet age, the entrenchment of the internet age. And just sort of in terms of I welcome the emphasis on freedom of expression and the rights of freedom of expression, but I do note, as Lorna said, it is the only rights which are talked about in the bill, and I would like to see an emphasis. I'd like to see other those trade-offs set out, other rights mentioned, and that the decisions on this should not be left to the ministers, but we need a national debate, some kind of and arrive at some kind of consensus that brings us together.
Thank you, Chi. We're just on 10:30. Damian, can I invite you to just make any final comments that you'd like to in relation to this question, and then we'll take the break and start again at 10:40.
Well, I don't have any particular answers for the question. I do want to pick up some of the points that he mentioned, because it would be easy to dismiss these points about people power and civil society involvement as well. People won't want to be involved. But I think we need to look again at that. If you look at the DSA, the European Union approach, I mean, there are multiple ways in which it, in fact, suggests civil society involvement through trusted flaggers and third parties being involved. I think there are funding mechanisms. There will be funding that goes to Ofcom for this. So civil society involvement could be funded. And I think if you look at what's done in these particular issues of principle, which don't cleave neatly across party lines, in which you want to remove some aspects of decision making from the executive, do really work rather well with citizen juries. And you look at the abortion referendum in Ireland and various other uses in Ireland and elsewhere. The Information Commissioner's Office has been experimenting with citizen juries and citizen assemblies. So I think it would be easy to dismiss, but I think it should be looked at seriously, this question of a societal debate and where you put the legitimacy. I disagree slightly with Chi that I don't think that we can say that the duty of care framework is somehow coming too early because we haven't had that societal debate. I think we can see it as a way of encouraging a debate which would be very difficult to get going otherwise.
I'm not saying it's coming too early, I'm saying it's about 10 years too late, to be honest.
Thank you very much, Damian and Chi and Lorna, for a fantastic and really fascinating panel. A great way to get us started for the day. Let's take a break here. The second panel on collective harm, individual harm and exceptions, which is already prompting some discussion, obviously in the forum and also in the chat. That starts at 10:40. So please stretch your legs, grab a glass of water, and we will see you back here at 10:40. Okay, it's 10:40, so welcome back, everyone. I'm delighted to introduce our second panel, which is the discussion on collective harm, individual harm and exceptions. Who or what will the online safety bill protect? And once again, we'll be, the panelists will present in the order in the programme. So first Edina Harbinja, then Glen, Tarman, and then Imran, Ahmed. Thanks to all the panelists for coming. Just a brief introduction. Dr. Edina Harbinja is a senior lecturer in media and privacy law at Aston Business School, and her principal areas of research and teaching relate to the legal issues surrounding the internet and emerging technologies. Glen Tarman is Head of Policy and Advocacy at Full Fact, and he's a non-profit leader with over 25 years experience in advocacy, campaigning, policy, communication, and the digital for charities, and in the area of international development, human rights, and environmental NGOs. And finally, Imran Ahmed is Chief Executive Officer of the Centre for Countering Digital Hate. You may have seen him in the media. He's an expert in online malignant behaviour and how bad actors use digital spaces to harm others and benefit themselves. And obviously the Centre is particularly concerned with this bill. So thank you to all our panellists for joining us, and I'll hand over to Edina to start us off.
Thanks very much, Lee. Thanks for the invite. And I think I had prepared a few points that I wanted to talk about, but then I had to rescope my contribution based on what I've heard already from the panelists before and the excellent talks that we all heard. So just referring back to Damian's contribution and his position on duty of care, I will have to say at the outset that I'm in the other camp. So in the camp that criticized the introduction of duty of care from the outset, and I've done that in some of my publications. I won't go in detail about duty of care itself because I should be talking about harm more, and this is what I will focus on. But in terms of duty of care, the biggest objections that some of this camp has had related to the way, to the proximity, foreseeability, proportionality, the lack of proof, risk assessment, and in conclusion, of course, suitability of this standard that originates from the health and safety law mainly, and whether it's a right way to think about speech. And again, I'm returning to what Damian has said, when he said that duty of care may be a useful way to think about regulating speech, and I really strongly disagree with this. Duty of care may be a useful way to think about regulation of safety, but not free speech, certainly. So going back to harm, and we have heard some comments on harm already, the definition of harm and the scope, social harm, etc. And some comments, of course, in the chat. So I will just read briefly the definition from the bill and some of the key parts of the definition, actually. So the provider, when it talks about the interpretation of the provider's category 1 provider's duties, the provider has reasonable grounds to believe that the nature of the content is such that there is a material risk of the content having or indirectly having a significant adverse physical or psychological impact on a child or an adult. It depends on the definition. So the problematic parts of the definition that we have identified in criticizing the bill, myself and other colleagues and academics and civil society groups are, in particular, this indirect harm aspect, then psychological impact and how that is determined compared to our existing legal standards. Then moving on to this group of people, individuals that this content could harm or risks harming. And we've heard of this standard already, adult or a child of ordinary sensibilities, that then extends not only to individuals, but groups of a certain characteristics, or an individual that shares characteristics of a group. And in the explanatory note, as Graham has pointed out, religion is one of those, for example. So blasphemy is a legitimate concern that I also share in terms of whether that harms and to what extent adults of ordinary sensibilities within a religious groups. I could expand on this and talk about perhaps what we've seen in the white paper, violent content. So what sort of violent content, if that is a harmful content, could harm adults, and where is the threshold for that? Is this related to some form of some artistic forms of violent content, including music, for example, or games? These are just some of the questions I've had. And then also looking at some other problematic aspects and less clearly defined harms, as the white paper has indicated before, and we don't see it as clearly in the bill. The questions around bullying and trolling in particular arise when we talk about groups and individuals of ordinary sensibilities. So who are we talking about here? People who are ordinarily sensitive, who are these individuals? What is this typical person? Do we have a standard? Can Ofcom really establish this standard? Can a private company, because they have the duty to assess the risk and deal or explain how they will deal with this content, can they really establish characteristics of this group that is of ordinary sensibilities and therefore harmed by someone who is bullying or trolling them? So these are just some of the questions that that are unclear for me, and that of course will be clarified in codes, and that Ofcom will be tasked probably to clarify, but not just Ofcom. And now we're coming to the private enforcement that we thought that the online safety bill will address. Well, it gives still a lot of power to platforms in assessing what these harms are, what the risks of harms are, what is indirect or psychological harm, etc., etc. So I don't think we're solving much here in terms of taking the power away from platforms. And we've heard these questions about power in the previous contributions. So I will conclude, because I'm conscious of time, with Ofcom. And I've said a little bit about my concerns, whether they would be equipped to assess harm from a conceptual and really problematic nature of this speech that the courts have historically been equipped to deal with. Well, more or less successfully. We can criticize that as well, of course, as anything else. But Ofcom, with its capacities, and I'm not sure what the investment, what sort of effective investments if Ofcom will produce in terms of equipping them with this difficult, incredibly difficult tasks of establishing the harms and adjudicating between some of those. And Lorna, in her contribution, she said that this is nothing new. So we have been giving the data protection regulators powers to determine aspects of data protection and privacy. Well, yes, that's right. But data protection is an incredibly detailed and principle-based legislation. So I disagree that data protection regulators were given a power to adjudicate between the rights to privacy and free speech, for example. They were not, in the same manner that Ofcom is likely to be tasked with when we talk about that. And in terms of Secretary of State, I would just add additional power that we haven't mentioned before, and we might want to consider, in addition to the list of exempt services that they can expand or reduce, there is an additional power to specify conditions and obligations for Category 1 services, which again is quite problematic in terms of the power of Ofcom independence and the capacities to do that. So I think I'll stop here, and I'm happy to engage in the discussion and answer questions later on. Thank you.
Thanks very much, Edina. Glen, would you like to deliver your contribution?
Thank you, Lee. Yes, indeed, and hi everyone. Let me start by saying, when we ask this question, who or what will the online safety bill protect? In so many ways, we don't really know yet. And I think it's worth just recapping some of that. It's not just because the bill is in draft form, and it's in part, of course, which so much is left to secondary legislation. But we don't know how the present Secretary of State or indeed future Secretary of States will use the significant powers that this draft bill gives them. That's it, if they don't get changed. And we're amongst the groups that would say those powers are too extensive and they need to be seriously looked at right from pre-legislative scrutiny. We don't know how the regulated companies are going to approach being regulated, how they will conduct their risk assessments. We don't know whether they'll change their terms and conditions, and in what ways, given wherever this legislation lands, or indeed other drivers that would make them change their terms and regulations. And really importantly, we don't know how the transparency will work. We've got some indications in the bill, but we don't know what exactly will be required, and we certainly don't know what will be offered or given in response, and that really matters. And we don't actually know how Ofcom will behave as a regulator, how it will act. There is always kind of leeway in the behaviour of regulator beyond, what's the text on the page and the remit, and I'll come back to that later on. And as others have touched on, we don't know how Ofcom's independence will be fully conceived and respected by this and other future governments. So that's a lot of uncertainty combined with what parliamentarians will take on in the course of the passage of this bill and how they see their role in oversight subsequently. I want to set that out, one, because, you know, as a fact checkers will tell you, you cannot fact check the future. So there's a lot about that future which we can draw on down now and have the deliberation and debate, but we actually need information to come forward to help us understand that. It's perfectly right that some things will come later. Some things need more evidence to be emerged, but it would be so much helpful if more steps forward. We need to know what needs to change in order for this bill to deliver real change in real people's lives. And that matters because bad information ruins lives, it promotes hate, it's very much impacting and damaging people's health, and it hurts democracy. Now, I'm assuming Imran may speak a lot to the promotion of hate, and I'm not going to. I'm going to touch on health, democracy, and one other issue. I'm going to speak largely not about the illegal, but the so-called awful but lawful, if that works according to your accent, because the harm to adults is really where, you know, there's a lack of clarity that needs to be explored. A few things I want to say just ahead of this is, you know, there are some who are arguing that the bill should be narrowed down to just illegal harms. And I would urge them to consider that that is an argument for the status quo, for the UK online environment to be in the bid of the internet companies of Silicon Valley, and for harms not to be properly addressed. And I think that's important, and others also have spoken to the need to address some of the strong voices that are coming forward and what they're speaking to. So I think harmful online misinformation is a really good way, I think, to start probing whether this bill is going to work, how it will work in practice, and health in particular. And we've heard from the Secretary of State in Parliament that he would deem COVID-19 misinformation, for example, as falling within the bill, and it's difficult to conceive that it wouldn't do. Well, let's start working through that. I'm not going to do that live for you now, but I think it is quite important now that we start working this through. I think there's actually an argument for harmful health misinformation to be included in the bill. Some harms should be coming later on, but I think health is one that's quite big up there. It also is one where we can explore more clearly this threshold of psychological or physical harm. You know, health is the obvious candidate to start working through that. But presently, we've got this vagueness of harm to adults. You know, how significant is assessed in relation to harm, and how can concepts like adults of ordinary sensibilities will interplay with these notions. That makes it difficult to see what will be addressed. And it raises lots of questions also about the internet company terms and conditions. You know, what dealt with means. How will Ofcom really give oversight to these issues? So I would encourage a lot of us to step forward and start looking through health misinformation in a lot more detail than is presently out there in relation to this bill. But I want to go a bit beyond and say, we also need to ask how the bill will improve democracy and address harms to democracy. There's serious questions around democratically important speech and how it's conceived. But I want to touch on protecting against harmful misinformation in elections. Now, elsewhere, we've seen with the elections bill this week some really good progress on digital imprints. So what we see online and whether we know it to be true or not and who's it coming from, this is really important as part of the legislative framework that's needed. Yesterday, we had the Committee of Standards of Public Life also coming forward with proposals on transparency around who's paying for what you see online. And so I think although the government's really reluctant to prioritise societal and collective harms directly, when this line to individual harm is not so evident, like it is with health, I think we should begin to revisit this. In one respect, because democracy and elections also interplay with these other harms, as others have spoken to. And also there appears to be provision in the bill that the Secretary of State can determine specific harms that don't otherwise meet this content that's harmful to adults threshold. So I think that we shouldn't just park that this shouldn't be about elections and democracy and misinformation that do impact on individuals. And I think that's a challenge that needs to be taken on. So I just want to end on another area which I think is super important. And that is the fact that, well, let me just touch briefly on freedom of expression first, because it's come up in lots of different ways. We're hearing a lot about very valid concerns, and some that perhaps aren't so, about content, individual pieces of speech, censorship and so forth. And some of those really legitimate concerns need to be looked at. We need to work through what is the impact of this in relation to this, let alone the kind of humans and machine side of moderation, and whether the legislation will tilt in favour of too much content taken down. But I would also like a lot more emphasis on freedom of expression responses to harmful misinformation. Fact-checking is a freedom of expression response to misinformation. And I would like a lot of us to begin to look at a lot more about those kind of approaches. You see it with kind of, whether it be friction and other things like the provision of good information. You know, we need to start talking about these issues. So lastly then is around media literacy. I do recommend Sonia Livingstone, who's on the next panel, has written a very good blog on the LSE site, and I do recommend that. There is, wherever you stand on these issues, nearly all the harms in part have some solution in citizens being better able to address their information worlds and their communities around them. And I'm concerned at the moment that whilst this is an improvement on the Communications Act in terms of improvement and not just promotion, we need to note that Ofcom is largely running a media literacy, media research function as part of its uplifting duties of media literacy right now. We need to completely transform that. It does great research. I'm involved in that. I do recommend Lee's recent research co-authored with others on misinformation, the Ofcom Commission. There is great research out there, but we need to start the conversation about what's needed to really enable citizens to navigate their information world, whether that's harmful, everyday misinformation, and so on. And there really isn't evidence at the moment, I think, of proper ambition around that. We look forward to the media literacy strategy from DCMS coming out next week. I think that will help that debate, but we need to look at what are the provisions in the bill that are going to do it. My last point is, we really need to look at what should come within the online safety bill, what should come elsewhere. And if it's not going to be in the online safety bill, those of us who are concerned about different harms in society, you know, need to know and need to be able to work with others. And of course, we all know that a lot of what happens online is because of really poor behavior offline and elsewhere. We can't see that online policy is going to be the solution to all of this, but let's all work in good faith to make the online safety bill the best that it could to be able to do so. Thank you.
Thank you very much, Glen. And over to our third panelist, Imran Ahmed.
Good morning, everyone. I do apologise if I'm a little bit rusty to start. It's 6 AM here in Georgia, so struggling a tiny bit. And to disappoint Glen, I won't limit my comments to hate. The Centre for Countering Digital Hate is actually itself misinformation, in that we look at misinformation, hate, and malignant actor use of the internet in a very broad sense. Most of you who've seen our work over the past year will have seen the work that we've done countering anti-vax misinformation, but we look at misinformation across the board and the way in which a variety of malignant actors have used the internet to create offline harms, whether that is health misinformation that's undermined our efforts on the pandemic, it's hate actors who drip misinformation and the precursors of hatred that lead to serious offline issues, or it's climate change deniers who use online spaces, the very corporatized climate change denial market, which uses online platforms to persuade us to wipe ourselves out as a species. Those harms are pretty stark to all of us. And we see these as part of a sort of that CCDHR analysis is that this is part of a cogent counter-enlightenment that's able to function, in fact flourish, converge, hybridize in digital spaces to create not just harms but new forms of harms as well. And the question that we've put to ourselves and that this bill is trying to answer is, has networking 3.5 billion people and letting rapacious tech billionaires decide what we see in the world, was that a successful experiment? Well, it was great if you want to know what your aunt's doing. It's not so great if you're a Rohingya Muslim. So mixed results, shall we say. It's a failed market. And we know it's a failed market. There's a considerable number of offline harms emerging. Legislators around the world are seeking to address this. The UK is not standing in isolation. In the US right now, we're working with people like Tom Malinowski, Anna Eshoo, Senator Mark Warner, who are putting forward bills on trying to fix the clear harms that they saw emerging after January the 6th in particular, in which misinformation about elections, about a variety of issues converged to create the storming of the Capitol, and also the anti-vax misinformation that's undermined considerably the US's attempt to control for COVID. I'm in Georgia right now, where fewer than 60% of people are vaccinated, have taken one vaccine shot, and they are unlikely to reach much more than that, to be frank, because there are enough people have swallowed the BS. So what are the phases that we've gone through in terms of trying to fix this failed market? Well, first of all, for the first 15 or so years, we decided to leave it to the companies to work it out for themselves, believing that tech billionaires, because they were young, were woke and therefore would fix their own platforms. Turns out that they didn't. The second phase was a sort of a rise in academia and civil society action around it. And frankly, that has failed as well. Because we couldn't possibly fact check all the misinformation out there, nor could we, as CCDH, for example, identify enough harms and get them to the attention of the public via, we're pretty good at that, I'd say, in terms of really high quality reports, really high quality press work, and having our celebrity amplifiers going out there and making a lot of noise about it. And I think that we've done as good a job as we can on that, but that's going to fail as well, because we are being overwhelmed by a deluge of misinformation and hatred. And so the question is, can governments now step in and provide both a backstop to create consequences for the misinformation and hate that we see spreading online, or can we, or can they provide tools as well and provide things like transparency of economic relationships to help civil society be more effective in its job? I would argue that they have completely failed on the latter in this bill, and there's just been a sort of a lack of thinking. And it's interesting because I think the UK, having been sort of pretty early to legislate, is actually pretty poor at thinking about how it operates, not just as a government, but also as a convener, as an enabler, as a creation of transparency and of tools for others to use as well. So correcting the market, not just through a status solution, but through a more complex and more interesting, potentially, and a more effective solution. And what is it that we're trying to solve? In short, that it's highly profitable to create harms online. It's politically profitable, and we can see that the spreading of hate and misinformation is politically profitable for people who are able to achieve political power by persuading people that the world is different to the way that science and any rational or objective or any fact checker will tell you that it is. If you can persuade someone the world is different to that, then you can politically benefit from saying, I'm the only one telling you the truth about it. There's economic benefit, and I mean, it's one of the areas in which this bill doesn't address is the sheer economic benefit of the production of misinformation and hatred. Anti-vaxxers have made a fortune in the past year. Hate actors have their sites monetized by Google ads and make lots and lots of money out of it. And again, the government doesn't have tools for dealing with that. And nor is it seeking to give itself the tools or give others the tools to deal with that through this legislation. But it's failed to do so through, for example, using its fraud powers or other powers that it has available to it. And then there's psychological benefit, and I mean this is the thing that everyone gets terribly excited about: trolling. I mean, trolling is really, really serious. It causes huge psychological harm. But it's a pretty disaggregated phenomenon, and it would seem to me that there's very little in this bill that would actually deal with that, because even in placing the duty of care on the companies themselves, and they have a legitimate excuse to say that if you have a platform which 3.5 billion people can access, people are mean. And that's a really, really tough thing for us. That's more of a cultural, and it will take more than just putting the onus on the platform. It will be a whole of society response that's needed to say that online malignant activity, trolling someone, is a harmful thing to do. Employers will have to say it, family members, and clubs that you're a member of, and that's something legislation is not going to do. You're not going to tell us, an employer that they must take disciplinary action against someone who behaves in a horrendously bigoted way online, but employers can. So, I mean, all in all, legislation, it's fantastic that the UK is trying to innovate and do something. I mean, I completely agree with others who said that we don't know what the impact of this legislation will be. This is a complex market, 3.5 billion people. And it's also a market that's set and in which many of the harms are created in the US, and the UK has a limited capacity to impact that, is the truth. But it's trying something, and it's going to take us time to go from the world's legislators having voluntarily abrogated their duty to protect the public from harms being created in emerging spaces, to this process of arrogating for themselves some of the tools necessary that they can start to at least see the scale of harm, the reasons for those harms being created, and the scale of response that might be needed in other aspects of society, whether that's civil society or state organs. It's a great first attempt. We need to see how that settles down, and over time we're going to have to regulate a market that is quite complex. The final point I'd make is that having Ofcom in there as and the duty of care model, which I can tell you, it's maybe not entirely supported in the UK, but it's considered a very, very exciting and interesting way of doing things by the legislators that we talk to in other countries who are looking to what the UK is doing. And of course, there are different models emerging around the world as to how to deal with this. The DSA is very different in its approach and scope. The online harms bills, online safety bill, whatever they're calling it this week, is great and different. The approach taken by Molinosky and Eshu, which would remove liability shield for algorithmically amplified content. The Warner approach in the US, which would remove liability shield for content that creates specific classes of harms. The approach used in Germany, in Australia and New Zealand. I mean, there are things happening around the world right now which are interesting. We are going to have to see how it all shakes out. But I would warn that just placing all of our hopes in Ofcom itself, given the concerns that many have really clearly expressed about Ofcom's ability to even understand the situation analysis, I think that there's a lot to be done, and I'm yet to be persuaded.
Thank you very much, Imran, and thanks to all the panelists. Some strong positions there right for our discussion. Would anybody like to start the questions or comment? Richard.
Great, thank you very much, Richard Wingfield from Global Partners Digital. And I want to maybe comment and then ask a question on what Glen said, and particularly around this category of content which is not illegal, but which nevertheless causes harm. And the traditional approach, as I've sort of understood it, is that where democratic legislators feel there is a particular harm in society that needs to be addressed, that kind of harm needs to be removed, and those who speak a particular harmful type of speech need to be restricted from doing so. The approach has been to prohibit it through legislation, either criminal or civil law, and have that enforced transparently through courts and transparent public processes. And this alternative approach, where Parliament will say, we're not going to make it illegal, but we're going to place a duty on you to stop it from happening. And unfortunately, the legislation does talk about how they will stop it rather than whether they will stop it, is essentially going, sort of avoiding the democratic process and trying to stop something by the back door. And my worry is that we will see particularly ministers sort of choosing what they don't like online on any particular day and sort of demanding that platforms and Ofcom do something about it. And I could just point the other week to the Home Secretary talking about people crossing the channel and videos on TikTok encouraging that. Now, what's to stop a minister suddenly saying that's the harm of the day, and Ofcom should encourage platforms to do something about it? So I guess my question then is are the panel comfortable with that as an alternative means of trying to restrict what people can say in society, or do they share my concern that it sort of cuts across centuries really of the way that we've tended to do things in a democracy?
Would anybody like to start?
I think if I may, I think from what I've said in my contribution, it's clear that I agree with Richard, actually. So I'll just echo probably what he has said, and the problematic nature of the legal but harmful content, and the definition that I have read out parts of, and the questions, and who are we tasking with this difficult decision on deciding what is legal but harmful, as opposed to what we traditionally know as being illegal, clearly as stated in legislation, and as Richard said, adjudicated by the court. So yes, I agree. I don't have a different position that maybe Glen and Imran would.
I'm happy to pick up on one point of it, which is, if you look at the bill, there is special circumstances in which the Secretary of State will require Ofcom, using its media literacy powers, to deal with what amounts to, serious things happening in our online environment. Now, there's lots of questions about how that power will be used, if it'll ever be used, what it's really for. There's lots of questions about whether media literacy works in real time when something really bad is happening, depending on what it is. But I think the other thing is, surely Ofcom should be able to sit on the evidence and know when a serious incident is happening and use the levers that it has to stop people being harmed in real time. And so I think that's one example, because we can speak about everyday information, but if you think of the beginning of the pandemic, when the information vacuums and everything meant, there was definitely an information crisis as well. If you think of, say, the Notre Dame fire, where rumors were spreading that certain groups were responsible for that, and attacks started happening, we need to start thinking about how this will work kind of in real time with serious incidents. And we also need to think about it as a sort of, how will this work in if you like, our everyday world of misinformation? Because as democracies, we need to work out how to deal with the fact that misinformation is actually a product of a healthy democracy that really values freedom of expression. So there's that dilemma there as well. But I think if you conceive of those two different kinds of environments where it's really disrupted because of certain reason, or where harm is happening on an everyday basis, are worth thinking through. I think a lot of kind of this is worth thinking through. How will this work in reality?
Thanks, Glen. Imran, did you want to add anything?
I mean, I would broadly echo some of the points said above, that the approach that they've chosen of creating a super regulator and having that under departmental control is under government control is pretty it's very, very centralized, it's very statist, and I'm not sure that it necessarily reflects what the British it's not necessarily, it's kind of it's a very centralized, very didactic solution to a very decentralized problem, and it doesn't allow for the kind of debate and discussion that's needed, and it's the clear distinguishing between harms that we can democratically agree. I mean, most of the stuff that we deal with is stuff that will kill people, whether it's like the work we've done on Islamic State, or it's on neo-Nazi extremists, or it's on anti-vaxxers. But that discussion needs to be had, and I'm not convinced that that we've yet come up with the sort of right mechanisms for having it. I'm not even sure the parliamentary debate is going to be particularly useful to it, because I'm afraid that the actual reality is that we do need to legislate in some way. The question is, there is a more fundamental question, which is, does the model itself work? And that's why I say this is the first iteration of legislation and regulation that's required. It probably won't end up being the final one.
Thanks, Imran. We have 3 questions lined up. Joanna, if I can ask you to state yours first, and then we'll go to Kruka and then Katie.
Yes, thank you, Lee, and thank you to all the panelists. I was particularly intrigued by Glen's points, fantastic points about what this bill will look like and how it will be enforced in everyday life. And this, correct me if I'm wrong, Glen, your approach to the openness we should have about emerging types of harm, and I would add emerging types of services provided. And in fact, I'm really concerned, and same happens with the DSA, as to why EdTech, educational technology, is not considered as a type of technology and provider that should fall within the scope, or if this has happened, how do you see this type of service and platform where harms like misinformation or bullying can be perpetuated?
Would anybody like to pick that one up?
Well, can I perhaps address sort of the way that the different types of platforms and how they're used in different malignant ways? And so what's identified there is a different type of platform, and how bullying and interpersonal abuse and harms can be created there. To my mind, like, there isn't even at a higher level, there isn't even an understanding of the split between the types of harms and how those harms are created and why they're created on different types of platforms. So we tend to sort of say social media companies, but they're used in really radically different ways. So Facebook, for example, is an information reshaping platform. It's where the drip of misinformation every day can start to color the lens through which someone sees the world. So what the type of misinformation and hatred that you see there is typically calculated. It's not in an individual post, it's persuasive over a period of time. You've got discourse shaping tools like Twitter and Instagram, which are about changing the hooks and the perceptions of events in real time. But also they're used for something completely different, which is to bully certain voices off those spaces. So to create cost for women, for Black people, for gay people to interact in those spaces, to cleanse them of those voices by using trolling. Then you've got fake knowledge points. So you've got news sites, which, well, BS sites that masquerade as news sites and are funded by Google Ad Tech, for example, and YouTube videos, which again are owned by Google and which are fully monetized. We've identified, and we're doing a campaign on one at the moment, which is run by a man who absolutely hates women to the point of encouraging violence against them in videos, which then have ads next to them. It's profitable to spread hate and misinformation. I don't even think that those sort of distinctions are there yet. And again, I mean, a lot of this we're leaving up to Ofcom. We're hoping that they will kind of work these things out over time. I don't know why we would believe that, given that it's been a few years in the making, and we're still not seeing a sophistication of analysis of the broad range of tools and how a broad range of malignant actors use them in very different ways for very different purposes.
If I can add off the back of Iona's great question, I think probably it's for DCMS to speak to what's in scope and why and the intention and so forth. But you touched on two really important concepts of openness and transparency. And I think the openness really matters if, as Imran speaking to, we are able to have a whole of society approach. Because at the moment, a lot of this might end up being quite a black box. You know, information is provided to Ofcom. It's quite opaque still, but it ticks the boxes of what's required in the resulting act. And so I think there's big questions there about, I certainly think Ofcom should have powers that the report gives some transparency powers, which are good, but it requires like an annual report. You know, an annual report is a report a year too late, often. Ofcom should have now something like the Financial Conduct Authority, where it can really, you know, get whatever information it needs. And there's also questions about how much information will be in the public domain. You know, is this for Ofcom's site only to be reassured? You know, where does this stop? And I think the more open those boxes are, the more able other actors will be able to be part of the solution. You know, it's quite good that there'll be a disinformation committee, but we need to think much bigger about how we need to gather up deliberative spaces to find solutions, and based on what information is available and how those are acting. This is quite a sort of top-down model, and I think we need to really envisage a very active citizenry being part of the solutions and the requirements here. The bill itself is very difficult to explain to the public. I think that's a problem in itself. But I think a lot of us need to begin to translate it to others and help people engage with this. And I know DCMS is open in that regard as well, and that's good. I'd like to see Ofcom also being active around that. Thank you.
Can I make one additional point? That
sure.
So we are yet to see precisely what the reaction of the platforms will be to this legislation as well, and that's the big unknown, and the firms. So I'll give you an example. I was on the weekend. I was trying to do some research to work out how many moderators Facebook has. They make it really difficult to work that out, but I think it's around 15 to 25,000, depending on which source you use. And there's a lot of different sources out there. They also use Accenture and other sort of outsourcers a lot. 7,500 of them are in Germany. There's a reason for that. It's because Germany actually bothered to legislate. Like, the platforms will react. They will themselves take action to start to clean up their platforms. They know what they're doing is wrong. And their strategies have been they've had three parts to their strategy. First of all, deny. Well, I don't know, it wasn't me. Deflect. Oh no, it's the bad people. It's not us. And then delay. And the delay has come through a variety of things. They bought off half of civil society, is the truth. They buy government employees in on a regular basis. So if you look at the revolving door in Washington, DC, where I normally live, and Facebook, there's half the civil servants I'm quite careful about talking to, because I know that they will end up at Facebook earning twice as much in 2 years' time. And so there's, you know, that they're very, very aggressive, very aggressively recruited. They've bought off civil society. They're like big oil. They've used the same strategies, and these companies they've delayed and delayed and delayed. And finally, when someone starts to act, they will themselves, because they know the day of reckoning is coming, So this story is yet to be told. We're not even at the very, very start of chapter 1. I think we're still in the prologue.
Thank you. There is a question in the chat from Krukai Potong about balancing free speech rights with spreading misinformation. How we might address that? Krukai, are you there, and do you have sound to ask your question?
Hi, Lee. Yes, thank you. So basically, I just thought that the amplifier mainly of misinformation and hate speech and the like are two things. One is technology, so that's pretty much algorithm, and the other is people being complicit without knowing they're being complicit in liking and sharing of this misinformation or the hate speech. So how would the emphasis on, for example, systems and processes approach address these? That would be my question.
Anybody like to pick that one up?
Well, I mean, we call that, the latter point we call inadvertent amplification through user activity. And the best example is quote tweeting someone that you dislike. You literally then amplify it. You tell the algorithm that this is contentious and interesting, and so therefore you push it up to the top of algorithmically generated timelines that aren't timelines. They're lists of content ordered by what is most likely to make you keep scrolling, and therefore having ads served up to you. And I mean, there's a lack of there's a lack of awareness around that. The funny thing, I mean, we just got asked by a government department if they would mind if they integrated our "Don't Feed the Trolls" guidance and report into their internal guidance for their staff on how to behave online and how to not inadvertently amplify malignant narratives. We did the same thing with DCMS and DHSC to create Don't Spread the Virus at the start of the pandemic about engaging with misinformation online. And that's just an educational piece. It's making people aware that there are different rules of physics online to offline. You know, directly touching or engaging with malignant information and the meme itself is really problematic. It's why we suggest that people don't engage with memes. They try and deal with the themes, the underlying themes. And you look at the work that CCDH provides from whether it's like things like the anti-vax playbook that show that, you know, misinformation actually is generally trying to spread very, very few core points, and it's dealing with those core points and those frames that's important. Or other work, but there's an enormous educational piece in there that I think is completely missing, and you're really sort of the purpose. It's really useful to identify that is a big factor.
Edina, did you want to add anything?
Yeah, I just wanted to add, yeah, so I agree with what Imran has said, and the question basically answers itself. So in terms of the technology and algorithms, there are mechanisms that we're seeing already in attempts to regulate companies, but looking at people and your second part where they're complicit in liking and sharing, I think that's where the media literacy we're talking about comes into play. And as early, of course, as schools, and we all know how difficult school funding in this area is, and that's where probably we will have to, I think, step up. And I know that other people have been working on this much more, but I don't see that I don't think that we should just regulate the origin part, but also the receiving part, which are individuals, and we should not see at all as Lawrence Lessig's pathetic dots at all, and someone being just regulated and fed, but also as an active, enabled citizen that is literate and educated. So I think that's where it all comes together.
Thanks, Edina. Glen, we're just on 11:30. I don't know if you want to add one final comment to that before we close for the break.
The comment I was thinking of really with around systems and so on is in relation to harm to adults. You know, each platform will kind of come up with its terms of reference. I think we need to start thinking of citizens also as users, and there are some really interesting provisions and requirements about user advocacy, the requirement of Ofcom and so on. So I think my thought as well with the media literacy side is, how can we, going back to Chi's point earlier, how can we and others, how can we make this a debate which involves citizens about the information world they want, and be active citizens around it, the services they use and everything like that. I think there's a tendency here to, and rightly so probably at the moment, looking at this legislation. So I hope that there's many more discussions and spaces like this, and I hope that they begin to open out to particularly the communities who are most affected by bad information online. And only that way, I think, will we get a new regime that stands any chance of working effectively. But there's some good minds and people and organisations on this. Let's expand that, hopefully, and try and get an online safety bill that will take us forward. But to Imran's point, I think that this is just one piece of a big, big puzzle, and just in terms of legislation, there will be more needed.
Thanks very much, Glenn, and thanks to all the panelists. There are some really interesting questions still in the chat. Unfortunately, we don't have time to address them right now, but perhaps they could be brought in the next panel, or the final panel indeed. But you've all delivered me a beautiful segue to the next topic, which is about the role of the public, citizens, users, consumers or audiences, the public and their responsibilities in the online safety bill. That session will start at 11:45. It's our last panel session before we bring everything to a close in the final discussion. So for now, thanks everyone for this second session, and we look forward to seeing you in 15 minutes at 11:45. Welcome back, everyone, and welcome to our third panel. This discussion is focused on citizens, users, consumers or audiences, the public and their responsibilities in the online safety bill. And I'm really pleased to welcome our three panelists. Professor Sonia Livingstone is a professor here in the Department of Media and Communications at the LSE, and she's long been engaged in media literacy in the digital. Her research is currently concerned mostly with children's rights in the digital age, and she currently directs the Digital Futures Commission with the Five Rights Foundation, as well as the Global Kids Online project with UNICEF, and has just been involved in the architecting of the general comment about children's rights in the digital age. Damian Collins MP is the Conservative MP for Folkestone and Hythe, and previous chair of the House of Commons Digital, Culture, Media and Sports Select Committee, and has long been an advocate of a bill dealing with this area of online harms, and we're delighted to welcome you as well, Damian. And then Graham Smith is a lawyer in private practice in London, focusing on technology, copyright and the internet. He is the editor and main author of the UK legal textbook Internet Law and Regulation. And his blog Cyber Legal, which I'm sure many of you are familiar with, documents his thoughts on law, the IT, the internet and online media, and he's been particularly made extensive comments already on the bill, and we're delighted to hear what you have to say today, Graham. As with the previous panels, the panelists will speak in the order on the programme, so Sonia first, and then Damian Collins, and then Graham Smith. Sonia, over to you.
Brilliant, thank you very much, Lee. And yes, well, this is one of my favourite topics. So the role of the public we're asked to think about. And I guess the broad observation, which actually has been confirmed, I think, by what's been said earlier this morning, is that it really matters how we conceive of the public. Without the public, media are pretty irrelevant and unprofitable, and yet, as we've also heard, they are persistently overlooked, much more talked about, rarely invited to speak for themselves. So some will recall, going back a bit, that the Communications Act of 2003 set out the principal duty of Ofcom, which was to further the interests of citizens in relation to communication matters and to further the interests of consumers in relevant markets. And traditionally, the consumer interest was kind of more thought of in relation to networks and services, and content was always a matter of the citizen interest. And somehow in the last couple of decades, the consumer interest in a market approach has taken precedence. And then, but even more now, I think we are all asking, where is the citizen interest? So this matters, I think, when we ask ourselves now what the online safety bill is for. Because again, I think folk are saying, and I would agree, that consumer interests are reasonably represented in the bill, especially consumers' concerns about online risk and harms, and through the insistence throughout the bill that there should be better provision of tools to improve individual user control and safety. But citizen interests are poorly reflected in the bill, with just a bit of attention to freedom of expression, but little recognition, as we've heard, of collective or digitally or shared digitally mediated harms for particular groups or for society as a whole. And I'd like to dwell on 2 points in the bill where I think there could be some specific improvements before it becomes law. So the first is the emphasis on risk assessment, which I think we haven't really talked about much yet, and I would contrast with risk-benefit assessment. So I say this as someone who's long advocated for better online safety. So of course I am highly concerned, and I know many others are, with efforts to risk assess and pay attention to potential natural harms. But if we just focus on risk, then the effect can be overly protectionist and doesn't take into account the cost to people's other rights, or to identify the potential benefits of digital services and kind of steering and shaping how services could positively enhance benefits for citizens. So there is, as we've heard a little, some limits on the kind of protectionist approach in the bill for journalism, but nothing really said about the wider public sphere. And I would just draw in the point made earlier about EdTech, something I've been looking into recently in relation to the Digital Futures Commission, where it's striking that a highly competitive market has been allowed to flourish with very little concern for the public benefits or the nature of the educational provision in terms of its quality. So could we, why not, replace mention of risk assessment with risk-benefit assessment? Or even better, why not, human rights impact assessment, and as we've been working on in the Digital Futures Commission, children's rights impact assessment, as a country that has ratified the UN Convention on the Rights of the Child, as well as other human rights instruments. So, as said earlier, formal requirements for citizen consultation would really help here, and that's important for process, but I'm trying to draw attention here also to the goals. A rights-based approach would be more holistic. It would be focused on individuals as independent rights holders and not just kind of the consumer interest as a kind of protectionist brake on otherwise unrestricted market power. Second, we see the let's say overemphasis on a consumer focus in the conception in the bill of media literacy, which is Chapter 8. The explanatory notes to the bill say that it expands and strengthens Ofcom's duties to promote media literacy, and this is with, yes, a welcome emphasis on disinformation, on education, on evaluation of interventions, and annual reporting. But still, that is, as it were, media literacy for consumers, not media literacy for citizens. Citizens communicate, create, they participate actively. And you might say, well, why would this be an emphasis in an online safety bill? And here I'm enormously concerned that Chapter 8 of the bill replaces Section 11 in the 2003 Communications Act, which was the only place, to my knowledge, where UK law made any reference at all to media literacy and its potential for many sectors in our society, including democracy, civil society, the cultural and creative sectors. So I absolutely echo Glen Tarman's earlier call for a much more ambitious approach, and I'm very concerned that by replacing media literacy in the Communications Act with media literacy as conceived in our online safety bill, we have narrowed the focus of media literacy to something that is purely about the protection of individual consumers. So I don't know, I feel like some arguments I've been making for many years, and one, along with others, and one is that this country actually has a very long-standing and internationally highly reputed tradition of research and education in relation to media literacy. And there are all kinds of insights from that research, including kind of very practically that developing tools that enable citizen engagement and creation of content is actually very effective in also raising awareness about the functioning of the digital world and the availability of protective services. And evidence that simple awareness raising works is actually less strong. But what do we have? We've had for 20 years, and I fear that we're going to continue to have endless kind of well-meaning, expensive, short-term awareness campaigns that don't visibly translate into very much behaviour change, as Lee Edwards herself and colleagues have just shown in their report for Ofcom. And what we know from that long tradition of research and from Lee's recent work is that it's the sustained pedagogic interventions that work, not the kind of showy campaigns by companies. So it's interesting that the bill tasks Ofcom with a responsibility for education. It's curious. One can only be skeptical that a market-focused regulator is it's appropriate within its remit to address media literacy as a sustained educational activity. Media literacy, as many have pointed out, is hardly valued by, I may say, or there's no track record that it's been valued by the Department for Education, no mention in the Education Act, and very recently systematically undermined in our universities. So, and even then, how is Ofcom to reach the adults who are no longer in formal education with their educational agenda is extremely unclear. One last point, if I may, and perhaps this is something I think is still unexplained and under-attended to, and that's, as I blogged for Media at LSE yesterday, the question that I think we should attend to more of why the very purpose of the bill is to do these two things together, for Ofcom to regulate internet services and to provide media literacy. So what is that conjunction, and how do we see the relationship? So, you know, I think I'm on record as being in favour of both judicious internet regulation and appropriate media literacy, but when they come together, something problematic emerges, because media literacy becomes somehow the fall guy, the backstop for the difficulties of internet governance. So, and it's just one step from that to seeing the failures of, or the problems of, online harms in our society as somehow the fault of the public that lacks sufficient media literacy, rather than the regulators or digital providers in doing their job. So every time I kind of hear a call for media literacy, I prick up my ears and I think, so when is it being called for? Is it called for as something that is a holistic and coherent educational strategy, or is it when we see some kind of regulatory failure? So I thought this morning's discussion on algorithmic amplification of extreme and hostile content was a case in point. This is a very bizarre educational message to give to the public. Don't share whatever you find interesting. Train teachers to keep up with the latest algorithmic tricks of companies and then spend a fortune on public outreach. I mean, this is just, rather than change the behavior of companies. So changing the behavior of companies, I've seen commented in the chat, is too difficult. That doesn't make the kind of commensurate task for media literacy an easy one. So we can't leave the media literacy agenda to kind of pick up whatever is controversial or impractical in the regulation of internet services. And I'm going to be interested to see how the National Media Literacy Strategy very soon is going to kind of weave together in a coherent educational program the rather ad hoc and tricky mix of problems that it's meant to solve. And I think we should be very wary that that agenda kind of transmutes into expectations that individuals should behave well online, rather than that society has a responsibility for creating a civil society and a well-functioning public sphere online as offline. I might stop there and just kind of urge that citizen interest, the principal purpose and principal duty of Ofcom in the Communications Act actually has not been superseded, and we should keep it very much in focus today. Thank you.
Thank you, Sonia. Damian, would you like to speak?
Thank you very much. It's great to be with you and to join this important debate. I think it is important to remember that, yes, there is a role for users in keeping themselves safe, being aware of how to use social media safely, what to look out for, what the warning signs are if you're looking at information that could be false. When we talk about the user-to-user experience of social media sites like Facebook, and Instagram and YouTube, where users are generating content for each other. Yes, if people didn't post bad stuff, then other people wouldn't see bad stuff, and that will be a step in the right direction. But I think this massively sort of underplays the fact that for most people's experience of social media, they have far less agency than you might think. That yes, it is true that if users didn't post harmful content or share harmful content, people would see less of it. But the act of spreading that content is largely based on decisions made effectively by the company through the design of its services. It is the fact the service has been designed to ensure that often extremist content and false content spreads more effectively than the truth because it's more engaging, and therefore more people are likely to see it. That people don't necessarily understand that just because they see a lot of a certain sort of content, it doesn't necessarily believe that that's what everyone on the platform is experiencing and seeing, but it's stuff that's being curated just for them and it's being directed at them just for them. I mean, I often cite the study that was done in Germany looking at Facebook that showed that 60% of people that joined Facebook groups that were sharing extremist content did so at the recommendation of the platform through its recommendation tools. So these are the sorts of challenges that we're dealing with when we think about the role of the individual. That yes, being a good citizen online is just as important as being a good citizen offline. You can be aware of the tools to protect yourself, but a lot of the harm is done through the design of the service. And the service is designed in that way for business reasons because it is an engagement platform based around selling advertising. And therefore the mission that the platform has every day, yes, of course it wants the user experience to be positive, because if it's positive, they'll stay there longer, but it wants them to be engaged. And if that means serving harmful content, because that's what's engaging that person at that time, then the platform is designed to do just that. So I think the questions will be for the regulator and for Parliament to discuss as the bill goes through the House, is I think the oversight the regulator should have of the way in which these recommendation systems work and the responsibility that these systems have for creating and designing the experience of the user. Now, if you have a teenage girl that is engaged with content on extreme dieting or managing depression or even concerns about self-harm, and as a consequence, more and more of that content is recommended to them, is that in itself harmful? Is it more than just the content that someone's created? Is it the system of recommendation? I still think when we talk about media literacy in the space of social media, we still talk about it almost as if it's it's on paper. You could print out an example on a sheet of paper of something that's bad. You can explain how it's bad. You can explain how you could try and avoid doing it, seeing it. But what there's no explanation of is the systems behind it that put that harmful content in front of the eyeballs of the person that is experiencing it. And so I think it's that lack of agency of the user experience which is so important. If you think users can't, even if you could train people to use the tools to help tailor your experience online, which are on the whole quite Some of them are harder to find than others, but and there's not enough awareness of them. In many cases, you can't block certain categories of advertising. You can just recommend you don't want to see them. You can't necessarily block whole genres of content being recommended to you through the recommendation tools on the different platforms because they're based on algorithmic selection. You can highlight that you don't like them maybe as they come up, but you can't stop receiving them. So these design flaws, I think, are a big problem, as is the lack of any kind of meaningful age verification system, which is, in terms of protecting younger users, I think the regulator could take a good look to try and see, can we guess to what extent the platform believes someone is younger than they've said that they are. But age verification tools are based on self-certification. And on the whole, younger people are trained because they want to use the service, because their friends are using the service, to lie about their age. And you can have multiple attempts at creating an account, even if you've lied about it, until you lie correctly to get your age right so you can get in. It doesn't even stop resubmissions from the same device where someone has tried to create an account when they were too young. So that lack of agency in the design of the systems, I think, is something that has to be an important part of the regulator's consideration of media literacy. I think for the government and for schools, yes, I think media literacy, and we've been discussing this in the all-party group on media literacy quite recently, is I think we need to think about it as something that when a child leaves primary school, they have a good understanding not just of how to safely create a safe password for their account, not to engage online with people they don't know. Some of the basics that I think actually kids are pretty good at already, but I have some basic understanding by the time they're 11 or 12 of how the systems that they are probably already signed up to actually work, why they see stuff, why it's recommended, how they can change those recommendation tools if they want to. But we shouldn't believe this is just down to the user. I mean, this is I think a bit like the debate about in the motor industry had in America in the 60s, where yes, if people drove safely all the time and everyone drove safely all the time, you maybe wouldn't need seatbelts. But on the whole, we decided that actually let's not take the risk, and seatbelts keep people safe. And just because you believe in seatbelts in cars doesn't mean say you're anti-car. You just see it as a sensible precaution. So I think I think Ofcom's going to have an interesting role here in weighing up the balance between good media literacy, keeping people informed, making them safe, and on the other hand, allowing the design of systems that in certain circumstances can actively cause harm through design, rather than just as a consequence of what users post. Finally, to say, I think on that, the question of anonymity, why is it that, sports stars, get battered with racist abuse on social media, particularly sites like Twitter where users can post anonymously? Do we just have to accept that that is the way of the world now, and that if we believe in freedom of speech, we have to believe that racist abuse directed at personalities through the anonymity of social media is a new normal? I don't think we should accept that at all. And I believe, although I don't have the data to prove it, that the growing incidence and cases of racial abuse online may be contributing to the rising number of cases of hate crimes being committed offline, which are higher now than they've been for several years. And so I think, again, in the round, the regulator has to consider these harms and the way the design of the systems may be causing harms, as much as looking at how we train people to try and keep themselves safe.
Thank you very much, Damian. And our final speaker is Graham Smith from Bird and Bird. Graham, over to you.
Thank you, Lee. So I think I'm probably going to take a rather different take on the title of this panel. Being a lawyer, it's probably a rather literal legalistic interpretation, but there we are. Looking at it from that perspective, I have to say I was a little surprised when I saw the title of the session, because the draft bill places no responsibilities on the public. I could almost stop there, but I won't. I guess by way of preface, I should say, like Edina, I am one of those who think that applying the health and safety, even automobile safety, duty of care model to speech is fundamentally flawed. I'm sorry to say that once that was adopted, I think it was inevitable that the government was going to sink into the quagmire in which it's now finding itself. And I fear that as we dig further into the draft bill, it's going to get worse, not better, as the fundamental contradictions in the draft bill become more and more exposed. I was probably rather unfair to Katie earlier when I put the blasphemy question to her, because it is literally unanswerable under the draft bill. And the draft bill is designed that way for these questions to be unanswerable, except ultimately by Ofcom in its codes of practice, risk assessments, and so on. And I'll speak in a moment to how I think that creates a rule of law issue, which at the very heart of this draft bill. So I said the draft bill places no responsibilities on the public. I mean, that's not really surprising because our own responsibilities, both offline and online, are defined by the boundaries set by the general law. Obscenity, harassment, defamation, civil and criminal law of all types. And as the government never tires of telling us, those apply offline as well as offline. What doesn't exist offline for speech is anything remotely like the duty of care concept for online speech that sits at the heart of this legislation. So thinking about the general law, online and offline, we are free to speak within the boundaries set by general law. And one of the concerns with this draft bill is the basic rule of law concern that Parliament is hiving off to Ofcom the power to create a parallel, entirely new set of boundaries. I say boundaries, but extraordinarily fuzzy and shifting kinds of boundaries, and being required to appoint the platforms as a posse of deputies tasked to police these rules. And we should say to police them predictively. There hasn't been any mention yet of the whole proactive monitoring obligations that are implicit, indeed explicit, in this draft bill, and the similarities that has to to predictive policing, and ultimately with users at the bottom of the pile trying to understand whether what we post might or might not be affected by this policing. And if we think the public's responsibilities should be different, well, the way to do that is to look at the criminal and civil law. So if someone thinks we should do something about blasphemy, then let's introduce a blasphemy Parliament and see what Parliament makes of it. What you absolutely don't do is to empower Ofcom under the umbrella of vague notions of risk of psychological harm to decide whether or not to reinvent blasphemy, and then exacerbate that by allowing the Secretary of State to tap it on the shoulder. Now, the government did say that it might include substantive changes to law in the draft bill, and we know the Law Commission is looking at communications offences, looking at things like maybe cyber flashing, pile-ons, and so on. But Law Commission hasn't finished its work, and the government hasn't included anything of that kind in the draft bill, or at least not yet. But if we're interested in what the responsibilities of the public are, then I would suggest that it's to the general law that we should look, not to any kind of indirect policing via a duty of care imposed on platform or service providers. There is there's, at least I think it's interesting, there's an implicit disjunctive responsibilities in this legislation. It is a little curious and potentially, I think, problematic from a fundamental rights perspective that the draft bill would impose greater legal responsibilities on platforms, on service providers, than on users themselves. So as the author, if I'm the author of a book, I have no duty of care to avoid causing a risk of psychological harm to my readers. And I would suggest that if anyone suggested that I should have a duty of care, that would be an extremely controversial proposal. There is a decision of the Supreme Court recently in Rhodes saying exactly that, very strongly rejecting that notion that the author of a book owes a duty of care to avoid causing harm, psychological harm to its readers. And nor do I have that duty as a social media user, and nor for that matter does the offline distributor of my book have that duty. What we are doing in the bill is something which is quite different from offline, which is imposing a duty on distributors of my tweets and posts that I don't have myself. And I think that's something which, if this was ever challenged, might be something that would come to the fore. I'm not going to say anything about media literacy. It's not my area at all, and I think it would be, I would be a fool treading where I shouldn't. So I'll leave it at that. Thank you.
Thank you very much, Graham. Three really interesting panels, bringing up some of the topics and treating them in more depth that we've spoken about earlier. But again, we have quite a lot of time for questions, so I'd like to open the floor to see if anybody would like to question or comment. Joanna, you have your hand up.
Yes, thank you, everyone. Really good points and really good perspectives. I want to start with Sonia's comment that she is being political, which is very much what is expected when we speak about literacy and education, and also pick Damian's point around agency. And I will start with saying something, the fact that when it comes to media literacy is about empowering the user, meaningfully empowering the user, the citizen, rather than responsibilize them. So my question is, do you think it's realistic to think that we can have effective media literacy interventions without approaching them in a holistic way? That means involving the experts, involving the beneficiaries, and by experts I mean both educators as well as agencies like the DFE and so on. So can we hope that such a meaningful media literacy intervention can be expected?
Who would like to pick that one up? Sonia, perhaps?
Sure. Thank you, Joanna. So the government is about to produce its national media literacy strategy, and I don't know what's going to be in it. So and that will be really crucial in figuring out what at least the government considers possible and what resources it's going to put behind it. I'm pleased at least that the bill does include an emphasis on the evaluation of the effectiveness of media literacy interventions, and they clearly should be evaluated against their goals, which are to reduce harm or reduce or realise rights, rather than, as it were, to help people to remember particular facts or enjoy the afternoon that they spent being told about this or that. So the evaluation has to be against the goals. And I think the gist of my points were twofold. One is that we haven't yet got clarity about those goals. And especially that we haven't got clarity about how the goals of media literacy relate to the other parts of the bill and are codependent with expectations regarding regulation of services. And secondly, I take you back to when the whole process of the online safety bill was first mooted, and the idea was that we needed a new regulator, and then the idea was that actually this would be given to the existing regulator, Ofcom. That's generally I'm happy with that, but I still cannot grasp why an educational task is being given to a market regulator and not to the Department of Education, or for those of us who remember something like BECTA, and a body specifically competent to provide media and digital literacy in very many dimensions beyond the question of online safety and online harms. There are all kinds of calls for digital skills, for digital literacy, for all kinds of literacies. This is profoundly not joined up, and it's, let's say, the right tool in the wrong hands, even though, you know, I have great respect for Ofcom in other regards, but they're not educators. And they don't have a track record of pedagogy and outreach in a way that will be effective in delivering the goals. So it's an enormous challenge, and I'm not convinced as yet that the bill has it right.
Thank you. If I can just pick up on the points you made about my remarks is, I think the agency point is important, because one of the massive differences between the experience of online media and other forms of media is that the service is designed around you, by other people making decisions about what they think you'll like and then actively promoting it to you. And there's no other media that's really quite like that. And to take Graham's point about a book, if you read a book that was, that had stories in it that were mildly harrowing, that as you started to read it, the stories got new stories that were even more harrowing, were inserted by the publisher as you went through it, making you feel even more scared. Then that's kind of more equivalent to the experience of someone on social media. So it's fair to say, well, actually, the organisation that's designed the service, their duty of care, I think, is not necessarily one to make sure that no one ever sees anything they don't like. But to actually say, is it responsible to actively promote things that could be harmful to someone, which is not a decision the user has made, it's a decision the company has made, and it's made it based on a system it is designed to make money for itself. And I think that user interaction, I think, is an important part of the duty of care, and I think that's what the regulator should be looking for in terms of duty of care, is the active promotion of harm, and recognizing that actually that harm doesn't just mean illegal. And of course, the regulator means that the platforms will be policed to see how good they are at removing illegal content, which they've not always been perfect at by a long way. So actually now there's no longer they're no longer free from the liability of saying, well, if I don't remove illegal content, ultimately it's not my responsibility because the person who posted it is one that's committed the crime. So actually no, there are standards you have to meet to remove illegal stuff you can see. But the active promotion of stuff that could cause harm, that could lead people to harm themselves or others, I think it's something that the regulator can take a view at, and I think it'll take a view at it in the way that it interprets the broadcasting code, which is already a live active example of a regulator working from a code that it polices based on guidance from Parliament, making subjective judgments about whether broadcasters have fulfilled their duties or not. And I think, again, that's how I think the duty of care principle will evolve within the realm of the regulator envisaged by the bill.
Thanks, Damian. Graham, I don't know whether you want to kind of add to the discussion. No, you're all right. I was just thinking in relation to the clarification around the duty of care, given the tension that you raised in terms of active promotion. No, you're happy to leave that? Okay. Damian, would you like to ask your question?
Sorry, is this Damian?
Yes. Sorry, apologies. Yes, Damian Tambini. Yeah.
Okay. I mean, I'm just sort of thinking through, Graham. You oppose this kind of delegation of standard setting to the platforms, and the rule of law argument is partly about this reference to things like the person of ordinary sensibilities. And I'm just sort of thinking about, because I agree that when it comes to harmful content, what you want is a system which is based on transparency, empowers users, and you want them to be using services where they are comfortable and not harmed, but other users might be more comfortable with different standards. But if you had some kind of definition which obliges platforms really not to apply these kind of societal standards, but a standard which refers to users of this service, whether you think that would be preferable when if they have to kind of take into account and research and so forth the harm standards of their users, whether there's any potential kind of redefinition or rethinking in that direction.
Okay, so I think firstly I'd slightly question the premise. I think the delegation is primarily to Ofcom, and I think I think platforms are then in effect doing what Ofcom tells them to do. So I would slightly question the idea that it's delegation to platforms. I'm not sure that. I mean, I'm not sure. I wonder how homogeneous a user community is, and whether cutting it down to your particular users would in reality make any difference, given the variety of quotes ordinary sensibilities there may be among users of a particular platform. I'm not sure I see how that would actually solve solve the inherent problem of subjectivity. And of course, the person of ordinary sensibilities is an attempt to introduce a degree of objectivity into this problem that, speech, unlike a loose floorboard, is subjective, and harm that is supposed, that results or said to result from speech is subjective. It's not like jabbing somebody in the arm with a needle. People react in all sorts of different ways to reading or viewing or hearing different kinds of speech. And I think that would be true of the users of a platform just as much as the general public. And the person of ordinary sensibilities is an attempt to try to overcome that, but it's an attempt that inevitably will fail. And you see that as you go down the cascading set of definitions, and it becomes more and more focused on first groups and then individuals until it ends up being completely subjective. And so I'm not sure that, I mean, nice try, but I don't think it solves the problem.
Thanks, Graham. Do you have any other questions from the floor? Or indeed, comments from the panelists to each other, reflecting on your contributions?
So if I can come in, Lee. So I still feel somehow as if this conversation is stuck between two modes, one of which is about what to do with content and whether it should be regulated and who and under what conditions, and the other is about what to do with the public. And I don't feel like we're taking the force of the point that Damian Collins has articulated just now, and others earlier, about the role of platforms and their business models, and the kind of the sheer determination and power with which they come after the individual or the public, rather than so the educational task is kind of, in a way, it's sort of by the by, and whether people understand how algorithms work and how platforms work and what their business models, I think they should understand all of that, and all of that should be transparent and taught and clear. But I don't necessarily think that is going to solve the problems. And if I can pursue Graham's analogy of the author, I feel a closer analogy would be the author with a paparazzi kind of in tow, taking their book and shoving it in the face of those who precisely do not want to read it every day, despite being told no, despite being told this upsets me, despite putting in place various kind of user protections. The paparazzi are still there when you open the door in the morning saying, read this book, read this book, read this book. And it's that kind of shit, that's what I was trying to say earlier about the kind of the freedom of reach and the activities of platforms mediating between content providers on the one hand, with whatever reasons they have for producing their content, and users trying to live their lives and interested or not interested. But the in-between of the technological mediation of these platforms is that's why I asked earlier, is this adequately addressed by the bill? Otherwise, both content providers and the public and their media literacy can never step up and solve the problem, whichever way whichever form we take it. And that's my primary concern, I think.
Can I come back on that, Lee? Or
of course,
comment on it? I think it's a really interesting point, and I think it exposes a bit of confusion, which is right at the core of what's been trying to be achieved here, because there seems to be a sense that that extending reach, let's put it that neutrally, is harmful or potentially harmful in itself, regardless of the content. In other words, completely innocuous content it is harmful to extend the reach of that. To take your example of somebody, hold on, to take your example of somebody constantly shoving a book in my face. I mean, is that harmful regardless of what the content of the book is? In other words, it is an inherently harmful activity, or is it harmful and only is it harmful when you take into account the nature of the content? And that I think is a lack of clarity that I think is implicit in, to be honest, some of what Carnegie have been saying recently, and also this concept that you can, this idea, which I think I see, that you can divorce, system risk from the nature of the content. Because if the idea is that you can divorce system risk from the content, it seems to me what you're saying is, what I don't mean you personally, but what one is saying is that actually it is that regardless of whether the content is harmful, quotes harmful or not, that process of constantly shoving things in people's faces is itself harmful regardless of the content. And I think perhaps in that debate that needs to be drawn out a little as to whether people are actually saying that the systemic risk is purely and simply in spreading content regardless of whether it's harmful or not, or whether it's only in respect of whatever you think is harmful content that is an issue. And I think that's something that perhaps needs to be brought out more.
If I just following that, to say that I think an interesting example, if you look at the insurrection protest in Washington on the 6th of January. Now that was actively promoted through multiple social media channels over several months, leading to that culmination of event. Now in a situation like that, the social media companies could say, well, the majority of people that were exposed to the content that led a large number of people to turn up and protest in Washington and to storm the Capitol building, leading to the deaths of 5 people. The majority of the people that engaged with the content, that content didn't turn up. So that wasn't harmful to everyone, but what did play a role in inciting quite a large number of people to do something that did cause harm and death. In a situation like that, I think it's a reasonable debate to have to say, at what point would you expect a social media company to look at what was going on and say, actually, is the responsible thing to restrict the amplification of this content? That if people want to choose to engage with it, or they choose to find it, or they're part of private groups that's being discussed, it's one thing. But actually, we think what is happening here is something that is a credible risk of harm, a threat to harm. And I think the incitement laws, both here and in America, are not that clear on how you would apply that in the world of social media. But what I'm not sure of is, in every situation, the answer should be to say that the platform itself that is being used for this purpose has absolutely no responsibility whatsoever.
Right, but that, which is fine, but then that is saying it's not just amplification per se, it is amplification of content that someone has to take a judgment on is harmful. So which to my mind makes it rather difficult to say that the approach is purely systemic, and the systemic risk is not in some way related to the content of what is being put out there, which is sort of what I see in some places. The idea that you can divorce systemic risk of the risk of the systems from the actual content which is being put out there. So I think what you're saying is it isn't just pure amplification, it's amplification plus content. Yeah,
I mean, I think amplification tools are probably designed to help people. You imagine if you're listening to music, and if you like one sort of music, you might like another sort of music, and then we're going to actively recommend it to you because you might enjoy it. And that will keep you engaged longer, but actually it's an enjoyable experience. I think the thing is, when you take tools that were designed for that purpose and you apply it to extremist speech, then they work in a very different sort of a way. And I think it's reasonable for a regulator to take a view about whether those systems, I'm not saying the systems themselves are always flawed, whether the company allows those systems to work in some ways, in ways that could cause harm.
So I think this is a helpful point of coming to, this is the conversation I think we should absolutely be having around the bill. And we do need a language to address questions of the interaction between the content and the technological amplification of that content. So it isn't is the content harmful or are the platform's actions harmful? But there's something between the two. So I'll give a couple of examples. One, payday loan is something you can shrug off. A payday loan, every time you turn on your social media to talk to your friends, begins to become a pressure. One image of a teenage girl looking thin and beautiful is not harmful in the least. If those are all the images you see, then for a teenage girl who is, who doubts her appearance, this is a problem. A barrage of messages of hate cannot be shrugged off. And as you say, Graham, rightly so, it does depend on the individual and their resilience and so forth, but it also depends on the volume and the reach and the personalization and the persistence with which that deluge of messages comes. So it's not, is the message harmful? It may be. A payday loan arguably is a little bit worse than an advert for Barclays Bank, but it's not so harmful anyone would ban it. It's the volume and the persistence and the reach of those messages that many people in very diverse circumstances are reporting as harmful.
Ultimately, someone somewhere has to take a decision. What do I have to do in this situation in relation to this content? And
in relation to this process of amplification.
Well, no, I'm sorry, but then you're saying that the process has no relation to the content,
no,
and that multiple pushing of the same content becomes harmful regardless of the content. I'm sorry.
Absolutely not.
Well, I'm sorry that. It's either one or the other. I mean, if you say the content is irrelevant, then you're saying the amplification itself is harmful.
No, it's the interaction. It's the two things in conjunction.
Well, but so you do have to look at the content as well as the amplification.
That's different from regulating the content. But anyway, that's.
Well, I think if you're regulating amplification, then how do you regulate amplification without also regulating the content if the content is relevant to the harm caused by the amplification?
Well, that's a good
Sorry,
point.
we're getting into it. I can see the chest, but
I'm inching forward.
Just coming on to this, Kate Morris of DCMS has just posted something in the chat which I think is relevant to this, because and that's saying that actually, as the bill currently stands, Ofcom won't be able to demand companies act against harmful speech, if it's not within their terms and conditions of service to do so. But when you actually, I think this becomes quite interesting, when you look at those terms of service, and then the regulator looks at them. So Facebook's terms of service says we do not allow hate speech on Facebook, and then defines that as a personal attack based on people's protected characteristics. So to Graham's point on blasphemy earlier on, if you personally attack someone because of their religious beliefs, then Facebook is saying, well, they don't allow that. Now, I think what's quite interesting here is the regulator to take a view, well, actually, at the moment, you're the arbiter of whether that's happening or not. But actually, now we have a role in determining whether we agree with your interpretation of your own rules. And I think that's something that becomes quite different. And the regulator have a view to see, actually, they put these things in the terms of service. Therefore, a customer has got the reasonable expectation that that's how they will run the service. But do they actually do that? I think there are two things then for Parliament to consider along that. Are all harmful attacks just ones that are directed personally rather than against a group of people? And I think at the moment the bill looks at it in terms of a direct attack rather than a general one. And then of course there will be the consideration should be for things that Parliament in the future considers to be harmful but illegal. Are there amendments to the law or to the code that reflect that as well? And I think the bill creates a mechanism where that debate can be held.
I hate to disagree with the civil servant in charge of this bill, but that characterization of what the draft bill says, I don't agree with. It says that it says that platforms have to say how this content, which may be priority content or other content in the risk assessment, should be dealt with, not whether. So the discretion to platforms to just deal with just express transparency. It's more than transparency that this bill mandates, I'm afraid.
But I think
can I just sorry, Damian,
if a platform said on its terms of service, we will never remove content, ultimately, regardless of what our terms of service say, we will never remove content unless it's illegal, then as far as the bill is concerned, the regulator couldn't go beyond that.
No, I disagree. Okay. That's not what the draft bill says.
Sorry, I'm just going to intervene. I'm just going to intervene and take chair's privilege, because I think this is a really interesting discussion, but I think it could also be something we could address in the final panel. And there are a couple of questions in the chat that I just want to draw in before we have to close and move on to that final panel. You know, there's some really fascinating tensions that you're bringing up, but I do want to give these other areas just a bit of visibility. So it's a combined set of questions from Andrew Livingston, and then related to that, Paul Bayer's question. Andrew and Paul, would you like to, well, Andrew perhaps first, and then Paul maybe follow up with your question. And then Ioana. Andrew Livingston, are you around? Oh, he has no audio. Okay, so I'll just read out the question. The question that Andrew has asked really is for Damian, which is primarily really about the validity of relying on the age verification process when people may circumvent it quite easily. And then Paul, you wanted to follow up on that in relation to the notion of personal responsibility. Do you have sound?
Hi, yes, just working out how to start the video as well. Yeah, it was just this notion of personal responsibility that's been spoken about this morning. At the moment, it's a matter of a few seconds to turn on one of the much advertised VPN, virtual private network services, and be completely anonymous on the internet. So how does that fit with the notion of personal responsibility when the person can't be traced? I would say that in addition to Get Safe Online, I come from a law enforcement background, so this comes from years of frustration of people being able to hide themselves very easily on the internet and frustrating law enforcement efforts.
Thanks, Paul. Damian, would you like to initially respond to those two thoughts?
Yeah, I think it's a perfectly valid point. I mean, I still think just because there may be ways around any system you try and design, or a way that some people could find around it, doesn't mean to say we shouldn't try and have, I think, better standards to at least make it as easy as hard as possible for people to get around the rules, and as easy as possible for people to choose to protect themselves as well, and have certainly to have for parents to have more oversight of what children can do and access from their devices. I mean, the experience of social media and of the web is largely an incredibly open one, and for younger audiences that obviously is problematic. And how easy is it to enforce the age appropriate design code, which has got a lot of good stuff in it, if it's very difficult to verify what people's ages actually are. The other thing I would say as well, and I think this takes us into another area we haven't got time to discuss today, but is that alongside the point I made earlier about lack of agency that users have, is lack of competition within this market as well. If you said, actually, I don't like the user experience on this particular social media channel because I don't like the fact that I can't control what I see, it recommends loads of stuff I don't like, some of which I find unpleasant, it's very difficult to pick up your data and move to another service that's interoperable. And I think it would be interesting to see if you had greater competition, greater interoperability, would actually standards rise by people migrating towards services that they thought were safer, and we don't have that system yet.
I think that's a valid point. We've certainly had people coming to us saying, as a last resort, saying, I can't get in touch with these corporate giants, the Facebooks and the Googles and so forth. There doesn't seem to be any way to interact with them and to say whatever's happened to them is wrong. But it's a free service. So saying, well, I'm going to take my business elsewhere has basically no effect on them. Why would they care? It's one individual out of millions.
I don't think they take the threat seriously because they don't believe you've got anywhere else to go. I think
exactly.
Yeah.
Thanks, Paul, and thanks, Damian. I would like to just pick up one last question before we close. We've just got 3 minutes before the next panel, but there is an interesting question from Madeline Earp of the CPJ about privacy, which we haven't directly focused on this this morning for much time. Madeline, would you like to just quickly ask that question? We'll have some quick responses before we start the final panel.
Hello, thank you. Yeah, I just wanted to comment that, amplification and algorithms is one thing. And at the Committee to Protect Journalists, our goal would be to see a definition of those that wouldn't infringe on legitimate promotional or investigative activity. But almost more urgent to my mind at the moment is to understand the loss of privacy that ordinary people would be subjected to if companies are required to proactively monitor content, particularly content that is perceived to be private between, you know, someone sending a direct message.
Thanks, Madeleine. Joanna, you had your hand up, and I just wanted to invite you to make one quick comment. I don't think we have time for a question, but did you have a comment to make before we conclude? Did you want to? What do you want to?
A very brief one. It could turn into a question, but let's not do that. So I think that the conversation as it shaped, I mean, it took me to question the idea of license to operate. Susanna Zuboff has said that these companies at this point have basically operate on a basis of a license to steal. I'm a teacher, and to be that, I'm a qualified person, and most people, wherever they operate, whatever the business they do, they tick some boxes, they have some qualifications and standards. And I think that this is something we should start to question. And when it comes to media literacy, perhaps we should start thinking, are the people who are the arbitrators of this ecosystem qualified enough to do it? Or should media literacy be a statutory duty for them to ensure and prove that they are taking the right expertise into account before they deliver those services?
Again, I think a really important question. Perhaps that is something that we could take into this final panel, along with some of the other thoughts that people have shared, which are these broader kind of underpinning realities of the Act or the bill, if you like, in practice. If it came to be in practice, then what, you know, how would it actually work, and what kinds of parameters do we need to see in place? What had to negotiate the tensions that have been raised this morning. I'm going to draw this third panel to a close now. Thank you so much, Sonia and Damian Collins and Graham, for your contributions. Really fascinating discussion, as I say, and that brings to a close the three kind of key areas that we wanted to address. Just before we go into the final session, which is a kind of a roundup and where we may, as I say, pick up some of these further debates. Katie, you'll be coming back in at this point, and we'll also have Richard Wronka from Ofcom. And Ofcom, of course, have been discussed extensively this morning, so I'm sure that he'll have much to contribute in this panel. No pressure, but it's worth, I think, just a recap on some of the things that we've raised through these different discussions. Perhaps, you know, one of the most critical questions is it possible to have an effective law based around a business model that fosters in many ways the negative consequences of digital life as much as it facilitates the positive consequences? How do you balance that tension between business and the drivers of business and the need to regulate in the interests of society? We've talked about various needs for clarity in key areas, harms, duty of care, the notion of risk, and whether that notion of risk should be central. The relation of the bill to other existing aspects of law, and the responsibilities that people and organisations have across those different aspects of law, including human rights, but also in relation to personal liabilities. The idea of this being a rather top-down approach rather than a bottom-up approach. Is there scope for more citizen deliberation? Is there scope for more public voice in the way that the bill might evolve? And if so, how might one do that? Some of the positive aspects of the bill, of course, the transparency, the promotion of transparency, the integration, perhaps, of evaluation in the media literacy element, which wasn't necessarily there so extensively before. And also, of course, these tensions between systems and processes, contents and platforms, content and reach, lots of things that still need to be explored and discussed as the bill progresses. As I say, we will be drawing together this content into a paper following the event, but just to conclude now, I would like to introduce the final panel, and I'm delighted to say that we have Margaret Hodge MP join us. She is the Labour MP for Barking. She's been an active community campaigner for over 2 decades and recently has been campaigning for greater transparency on profits from public contracts. And I know that Margaret is particularly interested in the idea of anonymity in relation to the bill. We're looking forward to your contributions. John Nicolson, I'm hoping, is here. John Nicolson, I couldn't see him earlier, but I'm really hoping he's here. I'm going to introduce him anyway and just take a punt. He's a journalist, broadcaster, and of course, current Scottish National Party MP for Ochil and South Perthshire. Sorry. He's the Shadow Secretary of State for the SNP for Digital Culture, Media and Sport, and he's a member of the House of Commons Digital Culture, Media and Sport Committee and Deputy Chair of the APPG on Global LGBT+ rights. Katie Morris, we have met already. Just a reminder for those of you who weren't here at the beginning, she is the head of online harms regulatory framework at the DCMS and is has been kind of listening to all of the comments this morning, and we'll take them forward as the bill continues to evolve. And Richard Wronka is the director for online harms at Ofcom, and as I say, Ofcom has been widely discussed, and we're very much looking forward to Richard's thoughts in this final panel. Once again, we'll have the panelists present in the order in the programme. So first Margaret Hodge, and then John Nicolson, Katie Morris and Richard. Dame Margaret, would you like to take the floor?
Thanks very much. This is not my area of expertise, so let me start on that, Dave. But just listening to the last 5-10 minutes of the discussion, one can see the difficulty of translating policy intent into effective practice, and I think this is going to be a challenge in relation to the progress of this bill as we go. So I come to it really from the perspective of a victim, but I think I reflect the views of many across the political spectrum. I've been quite surprised at the debates that we've had in Parliament at how much consensus there is on the issue. So I welcome the bill. I'm by tradition a freedom of speech advocate, and I always used to believe that social media was a sort of groundbreaking development that strengthened democratic discourse and facilitated much greater empowered individuals to participate. And I have slightly changed my mind and think it's now that there is a complex area that does require reform to limit abuse and harm that people experience, because that is a misuse of the freedoms offered by social media that impinges on the freedoms of those that are harmed. So that's my perspective. It comes from my own experience. I rarely actually use my own experience for legislation, but this has been an area where I sort of feel forced to do so. I think really, I've been in politics a long time. I'm used to attack, but what has happened on social media is something else. And I just wanted to give you, and sorry if it offends, but the sort of thing that I've had to put up with. There's one, these are very offensively, so apologies if they do offend people today. But one of the social media postings that we had was, to me and to Ruth Smeeth, nothing but a couple of bought and paid for by Israel, still not content after getting the biased pro-Israel IHRA definition adopted by the mewling appeasers within the party. About time these cretinous pieces of off back under their stones. And then another very regular sort of abuse that I get is I want her to feel despised. It's what she deserves. I hope somebody kills her. I really do. She's a lying, deceitful, hateful, who needs to be executed publicly so we can watch and laugh at her. The only support she deserves is a handrail to climb the gallows, the vile. So it's sort of in that context, and I've now lost my notes in the middle of that. It's in that context that I sort of thought, crumbs, something's got to change. The other thing to say that over a 2-month period, something you talked earlier about quantity, over a 2-month period, at the time I was fighting anti-Semitism in my own political party, and over a 2-month period when the EHRC report was published and Jeremy Corbyn was suspended from the Labour Party, I had 90,000 mentions. They weren't all hostile. They're vetted for me by Community Security Trust, but they were mostly hostile. That is a massive, massive presence on social media, something just in quantum that has been huge. And they weren't, and the other thing that I've learned over time is there is a terrific element of misogyny in all this. There's an particularly ghastly American website that is very anti-feminist and also pretty racist and anti-Semitic. And on this, what is interesting here is that if you look, Jewish women are responsible for everything that's wrong with feminism, but also that an analysis that was done back in 2018 when John Bercow, a Jew, and Ed Miliband, who was sort of just about, still a very much more prominent member of the Labour Party than I am, got 15% fewer mentions than I did, and then at that time than Luciana Berger did. So that demonstrates the misogynistic element in this. And more recently, of course, the experience of the Premier League and the racist abuse that has been identified over recent periods shows that this goes much broader. Now, most of the abuse is anonymous. And whilst I recognize that anonymity is a hugely important feature, certainly for particular groups, in particular circumstances, in particular geographical jurisdictions. So if you're a whistleblower, if you want to talk about a regime in a difficult area, if you're a victim of child abuse or a victim of domestic violence, you want to retain your status anonymously online. But I think the time for we have to start questioning whether anonymity is appropriate online. Public opinion's shifting that way. There's been a recent study by Opinion which shows which show that 4 out of 10 of the UK social media users would be happy to go through a verification process. And quite honestly, I think the idea that we're all anonymous online is anyway for the birds. We've got the Cambridge Analytica story that demonstrates how personal data has been used, and anybody who's known to switch on social media and look at the sort of ads that you see, you can see that they have massive knowledge about your individual likes and dislikes. So the sort of model I thought, and this is not tied to this, is a bit like PayPal. So when you go on PayPal, it's you give the provider all your personal details. Indeed, you could have a universal online identity, which could be shared by platforms. We could even move to that. But those aren't shared with anybody. However, if you use the platform for abuse, for online harm, then there would be a right for either the victim or for the or some of the authorities to access the personal details and therefore track you down and take action. And I think knowing that that would happen would, at a stroke, totally cut the amount of abuse and vitriol that many of us experience online. And again, to protect the identity of the individual, you could have a protected provider holding that identification material. It would not necessarily have to be used not necessarily have to be held by the platform itself. So and I think this, we've got to think this through. I know it's a really difficult territory for public policy, but I just think that if social media is to be used really to enhance democracy, it can't be abused in the way it has to be to silence people. Because the whole thing about the way, certainly I've experienced it, is that it's full of lies, it's full of distortions, and the purpose is to really undermine my credibility, and by undermining my credibility, silence me if I've got something to say on any issue. The only other things I would raise very quickly are I believe that actually, if we're going to have effective legislation, we have to move from getting the platforms, the companies accountable, to getting the individuals, the directors of those companies accountable. And I come to that view from all the work I've done around financial and economic crime, where just making we don't make corporations very accountable, but where we do, if they don't meet their legal liabilities, they are fined, and that fine becomes a business cost. If you can introduce individual director accountability and responsibility, that's a much stronger incentive for ensuring that those companies and their bosses take action to prevent, in this case, harm and abuse appearing online. And the very final thing I want to talk about, if I may, very quickly, is the issue of online scams. I'm repeating on myself. I don't know if somebody's repeating on me.
Yeah, that seems to have gone now. If you try again.
Great, thank you. It is the issue of online scams, which I've started working on with Martin Lewis. This also appears to be an omission, or I'm told that it's something that the government wants to think about and consult about after this bill has gone through Parliament, which is absurd because we all know how difficult it is to get legislation considered by Parliament. We have an opportunity here and we should use it to its fullest, not just say we don't want to widen the scope because that's too difficult and complex. So on the issue of online scams, Action Fraud, not the best of organisations, but they reckon that something like £1.7 billion a year is lost through online scams each year, and 85% of those, sorry, by scams each year, 85% of which are cyber enabled. And if you just look at crime generally, fraud now is about 30% of crime, yet the effort into solving it, just looking at the police, they spend 1% of the resources under it. So we're in this rather absurd position where the bill is going to cover user-generated content, but not advertising. So you can put up a review and that will be covered. You could put a video, a podcast, all of that would be in scope. But if you pay for a scam, that will not be covered. And we have to remember that all these platforms make their money out of the ads that they put on their platforms. So making them responsible and accountable to ensure that the ads are not scams seems to me a perfectly legitimate duty that we should place onto them, which would deal with a crime that not just causes loss of income and money, often to poor people, but actually causes huge mental distress, harm to individuals and their families. So the three issues I'm raising are: one, the issue of confidentiality; two, the issue of individual liability of directors; and three, the inclusion of online scams to come into scope, online adverts to come into scope of the bill, scam adverts on the bill. Thanks very much indeed, Lee.
Thank you very much. A great way to start the panel discussion. Hopefully we'll have a bit of time for questions at the end, but let's go straight to John.
Thank you very much indeed, and thank you for inviting me. I've much enjoyed the session. I've been with you since 9 o'clock, so I've listened to lots and lots of interesting contributions, not least Margaret's just now. I think most people agree that we want to reduce harms online. And I think there has to be an enhanced duty of care for users, and that the current system of regulation is clearly not working. A duty of care, incidentally, is a concept stemming from Scots law and a 1930s precedent, which I only recently discovered. It's an interesting story. A manufacturer of ginger pop poisoned a woman who drank the pop because there was a decomposed snail in the bottle of pop. So the question was, did they have a duty of care or not? They said, drinker beware. But the case went all the way to the House of Lords, and the House of Lords ruled that the pop manufacturer in Scots law did have a duty of care to the person who drank the sealed bottle that they'd manufactured, into which a snail had crawled, died, and decomposed. So that's the origins, which of course takes us straight through to TikTok today and the other social media companies. What responsibility do they have? Now, of course, they've long tried to argue that they're platforms, not publishers, and thus don't have responsibility for their content. Well, I don't agree with that. I was interested in the example that Imran gave us earlier on about just how many Facebook folk are working in Germany on content moderation in Germany. And of course, as he rightly said, that's because the Germans decided to hit the social media companies with huge fines if they carried racist, anti-Semitic, homophobic content, disinformation, or other abuses. Because previously they'd said there was nothing they could do about it and they shouldn't be the responsibility anyway, because they weren't publishers. Well, they changed when the Germans took tough action. Radicalization and disinformation are, of course, key concerns. And the issue is, how do we protect people from harm, especially now in the COVID era? We had TikTok, the TikTok bosses before us at the Commons Culture Select Committee, and it was very interesting. They told us that they did absolutely everything possible to try and control COVID disinformation. Now, it took my parliamentary researcher, Matt, about 5 minutes to disprove that. And he found a young American who looked like a pop star. She was incredibly glamorous, with very polished presentation and very polished films that she made. Helpfully, hashtag COVID lies. So she wasn't that hard to find. And one of her videos telling people that you were injecting yourself with babies if you took the COVID vaccination had an extraordinary 600,000 views. Now, again, it was Imran earlier on, wasn't it, who's told us about the low take-up rate in Georgia for COVID vaccinations. This woman had 600,000 views for her videos, clearly targeted at a young audience with the production values that she had in her image and everything else. By the end of the session, the select committee session, her videos had been taken down because I'd highlighted it and embarrassed the TikTok boss who's appearing before us. So clearly this stuff is dangerous and we have to find a remedy. But I do think there's a discussion to be had about how we prevent the content simply being displaced. And some analysis, I think, would be useful on the experience in Germany. What has happened with the Germans getting tougher on Facebook? Where does the harmful content go? Does it just go to dodgy sites that have less infrastructure to deal with it? I'm asking the question and I don't know the answer. But of course, misinformation and disinformation is currently not contained within the scope of the bill on the grounds that the bill's aim is to protect against individual harm, and disinformation falls into the category, they say, of collective harm. However, in the case of COVID disinformation, this can obviously lead to individual harm. A number of other themes and questions remain unanswered with regard to this bill. Age verification, for instance. Now, that was shelved by the Conservatives in October 19. That was just a week before it was due to be implemented. The official reason given was that the government wanted to have legislation that included social media apps and that the online harms bill would cover that. Now, I think there needs to be more clarity about the role of this in the bill, since many people think that children are not adequately protected from pornography online, for instance. Now, as a journalist myself, in my former career, I want to know more about how journalistic content is identified, since service providers must take free expression of journalistic content into account. And finally, I'd like to pick up on Margaret's points about anonymity online. Although not contained in this bill, there was, when we discussed this in the Commons, as she said, a remarkable amount of agreement about the desirability of account verification to tackle online trolling. And I was very struck by the fact that women MPs who spoke seemed to feel particularly strongly about this across the whole of the House. And I think a lot of them thought that while nom de plume were perfectly acceptable, there should be some system of verification so that any of us could decide to opt out of non-verified accounts. I think MPs, whether women or men, and women certainly get it much, much worse than men, would tell you just how much really vile trolling there is and how little the social media companies do about it. I mean, I'm a gay man, and I was calling me, and I wrote to Twitter about this, and Twitter wrote back telling me that this did not breach their community standards. So I wrote to them with chapter and verse of how it breached their community standards, and they wrote back a further 2 times repeating that it did not reach their community standards. So they've really got a problem. They're not taking it seriously. And I think any MP could give you examples, but I've been trolled on a regular basis by a particularly nasty organization called the LGB Alliance, who campaign against trans rights. And they were rewarding people who posted some pretty vile, sexualized and homophobic content about me and donated to their crowdfunder. And they were rewarding those people who posted vile content and gave them donations with a retweet. Again, you would think that would be a clear breach of Twitter's rules, since they encouraged a very poisonous pylon. But Twitter refused to do anything about it. Where the crowd of LGBT Alliance from their crowdfunders. The LGBT Alliance, incidentally, has just been given charitable status, but told that it has to be less poisonous online, otherwise the charitable status will be re-examined. Verification, of course, is also an issue for trusted news. And I know that Channel 4 News has supported the idea of verified news sources so that people who are looking online can distinguish between non-verified, between verified news, like Channel 4 as a trusted source, and non-verified news, which would be state propaganda, the kind of stuff that we see coming from Iran, from Russia, from Assad, the sort of things that we see attacking the White Helmets, for example, on a regular basis. Extraordinary propaganda against them. And it would help people, presumably, to know whether or not they're reading things that they should trust. I think this has been a fascinating discussion. I find myself swinging backwards and forwards as I listen to contributions when people are debating, which always suggests that the quality of contributions and the quality of the debate is very good. Many fascinating areas for us in Parliament to debate over the next few months, and of course for all of us in society to debate as well. So thank you once again for asking me.
Thanks very much, John, and we appreciate you attending. Can I hand over to Katie, please?
Thanks very much. And apologies, first of all, for not responding to every single comment. I have to say I slightly struggled to listen and stay on top of the amount of comments there's been. So if I haven't answered a question, it's not intentional, it's just my challenges in multitasking. It also means that my comments here are a little unpolished, but I'll try and respond to some of the key bits. So I think the first thing I wanted to come back on is around regulator versus systems and processes. And then within that, to use that to come back on the question of legal but harmful content accessed by adults. So I think that's causing quite a lot of confusion about what government's intent is. So I think I do have some sympathy with this argument that you can't totally talk about systems and processes without talking about content. And that's always going to be an issue. And it's also why we've gone through this process of trying to determine what is the content that company systems and processes need to be looking at. And I think that's really clear, and I hope that comes across within the bill. However, I think the fact that we've had to define the types of content companies are responding to doesn't in any way detract from the fact that what Ofcom will be supervising is those systems and processes. And what companies need to look at is how do those systems and processes work. And so I'll try and give a few examples of what we mean there. And I think it's worth kind of coming back to that point I made at the beginning of the risk assessment. Because I do think it's it's almost impossible for a company to risk assess without looking at what is it about their service that is enabling harm and that is having that impact on people, and what can they do to mitigate that. So when you look at the illegal duties, the duties are there to kind of identify and minimize that illegal content. And the way you can do that is, of course, through content moderation, and it would be wrong of me to suggest that content moderation is not a key part of this, training content moderators to make the right decisions, making sure you've got really clear moderation guidance. But equally, it's about what can you do kind of upstream to reduce the chance that so many people see this content. And that's where things like algorithmic promotion come in, it's things like behavioral nudges, and I think there's a whole host of kind of creative things that can go within there, and which Ofcom will set out in its codes of practice, that will be that mixture of kind of proactive duties. And I think it's really important to stress proactive duties doesn't just mean monitoring. There's a whole host of those kind of behavioral nudges, algorithmic programming, etc., that is not monitoring, but you can do upstream to try and limit the impact of harmful content, and that is built into the way the duties are framed. I think the next point in this kind of bucket I wanted to pick up on, actually, sorry, probably just worth there also, because I think it's come out so much, is this point around anonymous abuse and kind of pile-on abuse as well. And again, I think that is really built into the risk assessment approach, because again, we know that it's going to be much more harmful if it's pile-on abuse. And you can see that quite often it's the anonymity that drives the harm. And so again, when companies are risk assessing, they will then need to look at how does that service kind of perpetuate the harm caused by anonymous abuse, and what can they do within there to try and mitigate it. And we know that companies are beginning to do more, and this provides that regulatory requirement to go further. So then kind of picking up on this point around illegal but harmful content accessed by adults, and I know that there was a little bit of pushback to my statement that the government, neither the government nor Ofcom will be telling companies what they need to do with categories of legal but harmful content accessed by adults. And this hinges on the point of dealt with, and people saying that dealt with means that companies will need to react in a certain way. And here I would say, I think Damian Collins's point that dealt with could mean a company says the way we will deal with this is to do nothing. That we believe leaves open. However, I would say we think the commercial incentives are such that it would be very unlikely that very unlikely that a company chose to do this. We know that they have very strong commercial incentives to at least say they're taking action in this space. And what this really does is say, if you're saying you take action, then you really do need to be clear about what you're doing, and you need to follow through on that. And if you don't follow through on it, then Ofcom has that supervisory role to kind of hold you to account for it. So I hope that kind of responds to that issue. I think the other point I'd come in on was this point around the centralised kind of top-down approach. And I think that kind of touches on that point of government and Ofcom interfering in speech. And I hope what I've just said there explains why we don't believe that government or Ofcom would be, because the legal but harmful, what is there is for companies to come up with. But I think there's this big point around regulatory independence and how that fits in. And I would just say there, the way it has been, the legislation has been designed is to put kind of checks and balances around Ofcom. And ministers are comfortable that we need to have that within there. That is why we have the powers of direction, why you've got parliamentary oversight of codes, but we are really clear that it's critical that we maintain the independence of Ofcom, and we hope that we've got that balance right. I think, sorry, I just want to make sure I'm not missing any of the big points I wanted to make. I think, sorry, there was just, yeah, this point around engagement of users. I do think that's really critical, and I think there is a space for kind of more to be done in here. And I suspect that Richard Wronka will pick up on this, because it's obviously something Ofcom have experience of. We do we have put these duties on Ofcom to consult really broadly when developing the codes of practice, and the codes really are central for companies to understand what they can do here. And I think there is the space here for Ofcom to be consulting really broadly with people who are affected by online harms and other interested parties to make sure that those experiences are really being reflected in what they are telling companies to do. I think the other area, and this again would be for Ofcom to elaborate on, is the independent regulator. But given that we have said that when we're talking about legal but harmful content accessed by adults, we want companies to set their terms and conditions, I think there is space for there to be kind of encouragement that companies should be consulting with their communities when setting those terms and conditions and having that feedback loop. And the whole infrastructure creates that by kind of saying, when you set your terms and conditions, they need to, while you have discretion as to what they say, the way in which you develop them and the process needs to kind of meet certain minimum standards. And I think there is a space in there for kind of encouraging community engagement. And I really welcome more conversation on how that can be done, because I think government is really clear and has always been clear on the importance of multi-stakeholder approaches. I think, and then just one very last point, I think there's been a lot about what the bill's not doing. So things around kind of fraud, digital markets, competition, and all that side of it. I think I won't go into details here on what government is doing there, because it would take a very long time, and I don't think we've got that time now. But I think I just really want to make the point that this bill can't solve everything that is occurring that is bad online. It already is quite a broad scope, and it's already bringing in lots of companies and lots of different harms. And we are concerned that if you try to bring in too much, you end up spreading both the regulator and company resources far too thinly, and then the impact we do want to have will be minimised. And that's why we are trying to keep the scope of the bill focused. I think that's probably all I'll say for now, but happy to pick up on anything else in the questions.
Thank you very much, Katie. I know there was a lot to address there, so I think you've managed to cover most of those key points that have come up. Let's go to Richard.
Thank you very much, Lee, and good afternoon, everybody. It's great to be here, and I found it a really informative conversation today. I'd start by saying that we are supportive of the government's plan for a risk-based and proportionate regime that will hold online services to account for the steps they take to keep users safe. And the discussion today has really shown already what an incredibly important piece of legislation the online safety bill is. At the same time, we absolutely recognise the challenges in designing and then implementing a regime of this complexity and novelty. And from Ofcom's perspective, having clear and workable and effective powers and duties is absolutely fundamental to our goal of delivering a safer life online for the UK public. As Ofcom is preparing for this task, this really important task of regulating online safety, I thought it might be useful to give a perspective as we prepare for our new role. In doing that, I'm really conscious that my comments won't resolve many of the important questions that have been raised today around Ofcom's role or our future actions or the wider operation of the regime, but at least I hope it is a helpful contribution to the debate. I thought I'd start with what we're trying to achieve. Of course, our priorities will ultimately be influenced by the legislative process. I think it's fair to say there are some clear areas emerging where we expect to be able to make a difference. Namely, so firstly, I think improving the culture around safety in the tech sector. We're going to be holding online services to account for the way that they identify and consider risks to their users and the systems and processes deployed to manage these risks and the way that services integrate safety into the overall design of their services, which is a sort of theme that's cropped up through the conversation today. Secondly, prioritising the safety of children. Our research shows children to be more at risk of exposure to harmful online content. And we know that children face additional risks online, including to exposure to material that might be acceptable for adults. The third area is supporting freedom of expression. This has been a really key and clear theme today. How we do that? By encouraging online companies to take proportionate steps to protect people without imposing undue or unnecessary restrictions on fundamental rights. In doing this, we'll draw very closely and very carefully on our experience of supporting freedom of expression in broadcast regulation. We know, of course, this will be a challenging area. And then finally, in terms of priorities, sustaining innovation and competition, we're going to do our best to support platforms to taking proportionate measures, but also developing innovative approaches in order to support competition and ensure a dynamic market is retained. So a little bit now about how we are planning to do this in practice. Again, the precise detail of our powers and duties will be resolved by the legislative process, and that will, of course, influence what exactly we do. But we think there are some clear areas of focus emerging already. So the first is a very clear focus on users, and everything that we do will be centred on internet users and the UK public. We plan to use our research to ensure our work is anchored in users' behaviours and expectations. And we're also already evolving our online research and data programme, tracking emerging technology and using innovative tools to analyse user behaviour and experiences. We'll be looking to increase transparency in the online world. So we'll set transparency reporting requirements for online platforms, or at least some of the biggest online platforms, and then provide our own authoritative commentary to shine a light on practices and performance. We'll do this by interrogating platforms' incentives and strategies, and making good use of our information gathering powers and communicating this public where we can. We'll promote media literacy, heard today, and recognise the points being made around requiring a step change in our approach and ambition. I think those are fair points, although we are starting already over the last year or so to beef up our media literacy work. We'll look to set clear expectations wherever we can through clear codes of practice around safety systems that might be deployed, and the strength of governance structures and the amount of information we expect platforms to collect and disclose. But this isn't just about setting expectations, we'll also help companies to comply. And that will be primarily through guidance and support focused on services that may lack the experience or resources to develop their own ways of protecting user safety. And finally here, we'll look to be demanding but also fair in assessing compliance. And that means being evidence-based and proportionate in how we monitor and enforce compliance with platforms' new legal obligations, prioritising the most serious harms, and also recognising the implications for freedom of expression of the way we go about doing this. All of this said, we don't for one moment underestimate the complexities and challenges within each of these elements, and it's fair to say there are no silver bullets here. We're also very much alive to the point that heavy-handed regulation could be counterproductive, and we're going to strive very hard to preserve the very clear benefits of being online. Finally, I'll just say a little bit about how Ofcom is getting ready in kind of practice. So firstly, widening our skills. We're scaling up recruitment already, including appointing experts with in-depth understanding of particular harm areas and the drivers of harms, and augmenting our freedom of expression expertise, although that is an area where we already have a high degree of expertise through our broadcasting role. We're also opening a new technology hub in Manchester, which is to help us attract skills and expertise from across the UK as well. We're embedding the lessons from other areas we regulate, so in particular our work around the telecom security framework, and especially our regulation of UK established video sharing platforms, which a couple of panel members have touched on already today, which is, from our perspective, a timely opportunity to test and trial the approaches that we can deploy within the online safety regime. And finally, deepening our partnerships. We're really keen to build strong relationships across civil society and academia and industry and the public sector to leverage the existing expertise and different perspectives that those organisations and individuals can bring. This will be critical, I think, to the sort of situational analysis that Imran mentioned earlier in the context of disinformation, but I think probably applies across all of the harm areas. Separately, we've already made a step change in the way that we work with other regulators through the Digital Regulators Cooperation Forum, including with the ICO and the CMA and the FCA. And we're really keen to work closely with government, parliament and others as the legislative process plays out. Finally, we'll be looking to build on strong relationships with overseas regulators and work to kind of help build global momentum and to achieve consistency or at least alignment in different international. We will need a consultative and open-minded and adaptive approach. And we really look forward to working, continuing to engage with the participants in today's discussion, and no doubt a much wider pool of people as we go about doing this.
Thank you very much, Richard. And I think that's an incredibly comprehensive kind of overview of a number of different next steps and intentions associated with the bill that, as I say, pick up some of the topics that we've spoken about here, but also suggest that there are far more conversations to be had before the bill is completed and finalised. It's 13:28, so we are just on time for the close. I can't see any immediate questions in the chat, although there are a couple of comments, so please do look at them. But I think on the basis of the fact that nobody has their hand up, I will say thank you to all of the panellists for this session, Dame Margaret Hodge, John Nicholson, Katie Morris and Richard Wronka, and indeed all of the panellists from the rest of today. Katie, of course, you started us off as well. Professor Lorna Woods, Dr. Damian Tambini, Onwurah, Edina Harbinja, Glen, Tarman, Imran, Ahmed, Professor Sonia Livingstone, Damian Collins and Graham Smith. You've all been really fantastic to host as panellists and have really generated a huge amount of discussion around the bill, which will be incredibly productive. As I say, we are going to put this, the content of the discussion into a paper which will be submitted to the pre-legislative scrutiny committee. And for the speakers in particular, I'll be in touch with you separately about that report. Just a reminder also for all the attendees that the recording will be available later on the LSE website. We'll email you about where you can find that. If you would like to be removed from that recording, then please let us know and we can edit you out. But with that, I'd just like to thank everyone. There's one final thank you I have to say though. First of all, thanks to Loam Tesfaye, Emma Goodman and Imogen Fairbairn, all of whom are in the background making this happen and providing incredible support to bring us all together today. So thanks to all of them for their fantastic work as well. Many thanks to all of you for coming, and we look forward to seeing how the conversations evolve.